Good morning. Welcome to oral argument. Clerk may call the calendar.
Good morning. The Supreme Court of California hearing oral arguments in San Francisco on Wednesday, September 6, 2017 at 9 a.m. Case number S226036, City of San Buenaventura, Plaintiff, Cross-Defendant and Appellant versus United Water Conservation District et al. Defendants, Cross-Complainants and Appellants. For Plaintiff, Cross-Defendant and Appellant, Mr. Michael J. Colantuono.
Ready.
For Defendants, Cross-Complainants and Appellants, Mrs. Cheryl A.R. and Mrs. Jane Ellison Usher. Case number S235412, Alexander Vasilenko et al. Plaintiffs and Appellants versus Grace Family Church, Defendant and Respondent. For Respondent, Mr. Paul A. Dolomir.
Yes, ready.
For Amiki Cura, Association of Southern California Defense Council, and Association of Defense Council of Northern California and Nevada, Mr. Eric S. Burstyn. And for Appellant, Mr. Frank J. Triano. Case number S089311, The People, Plaintiff and Respondent versus Christopher Henriquez, Defendant and Appellant. For Appellant, Mr. Oscar Babro. And Mr. Scott Kaufman.
Good morning, and we're ready.
And for Respondent, Mrs. Ronnie Dina Pomerantz.
Good morning. Thank you, Jorge. Two announcements, and the first is that we have a class of 25 international students from the University of San Francisco School of Law joining us this morning. Also in attendance with the class are visiting scholars, international scholars from China, and judges from South Korea. The group is led by Professors Julianne Cartwright-Traylor and Jeffrey Kalustian. Will the professors please raise your hands? And thank you for bringing your classes here. And the students, could you please let us know who you are with a show of hands? Thank you and welcome. Also, let the record reflect that on this case, City of San Buenaventura versus United Water Conservation District, the Honorable Joan K. Urian, Associate Justice, Court of Appeal, 4th Appellate District, Division 1, sitting assigned. And counsel, you may proceed when ready.
Good morning. Michael Colantuono appearing for the City of Ventura. It's usually helpful to start a case by articulating the rule that I intend to defend. This case requires a meta rule of decision because the Constitution gives us two competing rules of decision. How do we decide whether Prop 26 or Prop 218 governs this case? I think the Constitution gives us the answer. Prop 26 says that it applies to any levy, charge, or exaction of any kind imposed by a local government, with 7 express and some implied exceptions. So we start with, is there an exception? The obvious exception of relevance here is Prop 218, because those revenue measures governed by 218 are exempt from 26. So the way to decide this case is initially to decide whether you're dealing with a property-related fee within the meaning of Proposition 218. I think the answer to that question is yes, not because that answer was inevitable. This court could have chosen a different path when Justice Mosk was still among you, but it didn't. And given the respect that this court has for stare decisis, you should think very carefully before you choose an intellectual path that has been forsaken for more than a decade.
So, counsel, what is property-related in a nutshell from your perspective?
A property-related fee is a fee that bears on one merely because you own property, including a few property-related services which are so essential that foregoing that service is tantamount to foregoing use of the property. So water supply, trash services, and I'm missing a third, from Article 13D, Section 6C, are partially exempt from the procedures that the Constitution imposes on property-related fees. It would not have made sense to partially exempt them if they were never included in the first place. Now, you might have decided that the only water, sewer, and trash fees that are within the reach of Prop 218 were those collected on the property tax roll. That might have been a sensible choice, but you didn't make that choice. You decided in the Bighorn case to reach those water charges which are collected by a monthly bill based on metered consumption.
Can I start off by asking you why this choice of framework matters for purposes of the particular challenge that you're bringing here which concerns the manner in which the charges are calculated, the amount of the charges are calculated. In your view, is there a difference between the proportional cost requirement under Proposition 218 and the fair allocation requirement of Prop 26?
I think there is a spread between those two standards, but I think the record here is so inadequate that you could decide this case without articulating how wide that spread is. This record is fundamentally inadequate to justify this fee under either standard.
And how would you describe the spread?
Prop 218 tells us that a fee must be proportionate to the cost of serving the parcel. That can't mean what it says. San Diego has 250,000 water customers. They can't do 250,000 rate makings. So Griffith helpfully tells us you can establish rationally drawn classes of customers who receive service in a way that their costs are logically the same and do class-by-class rate making. But you do have to do class-by-class rate making, and each class has to be balanced on its own costs and revenues. Prop 26 consciously copies the standard this court articulated in the SDG&E case from the Fourth, but also in St. Clair Paint. And that standard is more generous and looks to the program as a whole. Now, 26 doesn't merely codify St. Clair Paint. There was no need to do that. A lot of money was spent to pass a measure to change St. Clair Paint. But St. Clair Paint is not changed in the last paragraph of Prop 26, which articulates this standard. It's changed in the language of the exceptions. So if we were to view this as a case involving a fee for a service or a benefit under Prop 26, you'd have to show that it was a service provided directly to the payor, that there were no what I call free riders, no beneficiaries of the service who are not charged. And those requirements of direct service and no free riders were intended to change the result in St. Clair Paint, where you were charging paint manufacturers to provide health care to children who ate paint chips.
And there's also, of course, a centerpiece of your briefing is the fair allocation requirement, that there be a reasonable relationship between the cost to the payor and the benefits that the payor receives or the burdens that the payor imposes on a particular service or benefit provided by the government.
That's right.
In your view, how does that allocation requirement compare to the proportionality requirement under Prop 218?
They're obviously parallel inquiries, and many rate makers will engage in exactly the same analysis to satisfy both of them. But I think there is a shade of difference there, that 218 is somewhat more demanding than 26, because 26 harkens back to a set of cases that this court and other courts decided that allowed more freedom to allocate costs. Now, a case where you may actually need to look more closely at the standard is a case on your docket involving the State Water Resources Control Board, where they had 8 programs funded under one fee, and you're going to have to decide, is one fee for 8 programs constitutionally sufficient? And how do you tell, as a constitutional court, what one program is and what 2 programs are? That kind of line drawing exercise really is required in the Water Resources Board case. Here, the record's fundamentally inadequate. The reason it's fundamentally inadequate is they took the Zone A charge and called it general fund discretionary money, commingled it with other discretionary services, and rendered their books incapable of proving what the Constitution demands that they prove. They can't show that the Zone A charge is not higher than the cost of the services provided, because it goes into a bucket with a bunch of other things and funds more than what the Zone A charge was imposed for. They can't show that they're not using the Zone A fee for unrelated purposes because it's in their general fund. They can't show that it's reasonably related to the cost of serving any particular customer because of the commingling. This record is fundamentally inadequate. It is so inadequate that it gives you the option, should you choose it, not to get very far into this distinction between 26 and 218.
Did the Court of Appeal address the reasonable relationship requirement in its opinion?
The Court of Appeal applied half of Prop 26. They said, if you show that your fee collects the cost of the program in toto, we're done. We don't need to examine the allocation between fee payors. With respect to the Court of Appeal, that's just wrong. That's not what the Constitution says. If that's what the Constitution says, there would have been no need to adopt Prop 26, because that's suspiciously like what St. Clair Paint said. And a lot of money and effort was spent to change St. Clair Paint in some way. I'm not sure you need to answer entirely today in every way that it was changed, but it was certainly changed in some way. And there's a 2-prong test, and you don't pass go and collect $200 if you only analyze the first prong.
So if there's, as you say, a spread between the relevant standard about the calculation of the amount of the charge under Prop 218 and Prop 26. The trial court's findings here were based solely on Prop 218. Would those findings alone be sufficient in your view to satisfy the inquiry under Prop 26? And if yes, why?
No. And the reason I say no is that I'm quite concerned about the standard of review and the mechanics of review. And the reason that I'm concerned about the standard of review and the mechanics of review is that it goes to the role of courts and legislators in our system. You've been asked to do something very peculiar, something that no administrative law professor, and I think we have two of them with us, would ever appreciate, which is apply independent judgment review to legislation. Independently judge pure choices of discretion among principles. Your business is applying principles that have other sources. How do we make sense of this? First of all, I don't think an appellate court gives deference to a trial court on a record that is developed where they're construing a cold record. You have the same institutional competency, and in my view, greater competency because of your resources of time and talent that busy trial courts don't have to penetrate the record. So let's start with what the trial court's job was. The trial court's job was to confer some deference on the legislative findings under Fukuda, but not absolute deference. And I think Judge Anderle, who I deeply respect, worked hard and wrote some brilliant opinions here, gave too much respect to a fundamentally inadequate record. Let's talk about the Zone A versus Zone B problem. Zone A is district-wide. Zone B is just the Freeman Diversion Dam. Zone B is the downstream portion of the district that benefits from the recharge that the dam makes possible. So this district has decided legislatively that there's a difference between Zone A and Zone B. But they weren't consistent about it, and they took many programs that benefit Zone B and charged them out of Zone A. That is the kind of choice that the trial court should not have deferred to because it's illogical. And certainly this court need not defer to the trial court when it makes that kind of a judgment.
Can I go back, counsel, to the prior step about what is property-related?
Please.
218. So our decisions in this area are difficult to decipher, to say the least. But doesn't this case differ from Bighorn, at least insofar as that case involved ongoing water supply to particular properties, and there was not a kind of traceability problem that adheres here, which is that the service being provided is the recharging of the groundwater basins, and it's multiple basins, right? And so as the Court of Appeal reasoned, I think, here, that it's very difficult. There's a traceability problem between what is the nature of the service that's being provided and who benefits to and to what degree. So the line that can be drawn between the service provided and the property benefited is not as clear here as in Bighorn.
It is nice and simple to apply these rules to an urban piped water system. If you're not connected to the system, you're not benefiting the fees on the services of those who do. But the Constitution speaks about water and sewer, also pipes, and trash. There's no nifty little connection of trash. Think about the Farm Bureau case, which involved a fee collected on the property tax roll to recover the cost of operating the county landfill that protected farmers from having their fields used as de facto landfills and made sure that we socialized and collectivized the solution. That fee, I think, is within the reach of Prop 218 because it's on the property tax roll, you pay it because you own property, and it provides a service that's directly related to property ownership. So the nice distinction you want to make based on pipes doesn't work for trash. So I think you need a little more flexibility. And I think the 6th District persuasively tells you why you should reach this fee. And the reason for it is not least stare decisis in the fact that every major groundwater agency has been sued over the last 15 years. And every one of them has had a decision handed down or a settlement built around Prop 218. And the legislature passed the Sustainable Groundwater Management Act, called SGMA, and said service charges that produce water are subject to 218. Regulatory charges that produce regulation and reduce demand to the available natural supply are not. That's a legislative characterization of the Constitution, in my view, that is subject to some deference here under Green. So you could go a path that the court didn't take in Bighorn and that the 6th District didn't take in Amrine. But you would be disrupting an awful lot of law and an awful lot of decision-making made around the state. And to what end? You get out of the Prop 218 frying pan into the Prop 26 fire and end up with a slightly different standard of review to develop. And you end up, I think, in the same place, affirming because this record is so inadequate.
Although there are other differences besides the cost allocation requirements between the two constitutional schemes, are there not?
The primary difference is the procedural mechanism of Prop 218, and 26 has none at all. So in the 26 world, all it says is what the standards are, processes provided by substantive law that governs any particular fee. So one of the points I would make is that this mechanical question, what does the legislator do? What does the trial court do? What does the appellate court do? Who bears the burden to produce a record? That's been true since Prop 13, the agency does. Is there a duty to make a prima facie case by a plaintiff to tell the court what the issues are, or does the respondent have to show up and brief everything? And once they've made a prima facie case, that's what's necessary to trigger our burden of proof. These mechanical issues are quite nicely laid out in a decision of the 6th District called Great Oaks. But you granted review prior to July 1 of last year and therefore depublished that decision. I made a request on behalf of some clients that you republish that decision, and that request remains pending before this court. So as you consider wrestling with the standard of review, mechanics of review conundrum, I would counsel you, bench and bar need guidance. The 6th District did a pretty good job of it, and you could do a good for the law of California without getting into the weeds on that issue yourself, simply by republishing Great Oaks.
Speaking of guidance, counsel, we can come back to Prop 26 and Prop 218, but let me ask about Prop 26 and Prop 218 in a different way and ask you to tell us whether you think that Water Code 75594 is constitutional.
You have a choice. Either it's unconstitutional or it's not. That's a binary question. But here's what's happened if it is constitutional. This agency, a creature of statute, which has no police power, it has no power under Article 11, Section 9 to provide utilities. It's a creature of statute. It has only the power that's expressed or reasonably implied from its formative act. That's all they have. If they only have the power to charge for water supply, when their record so happens to produce a ratio of rates on M&I to ag in the 3-to-1 to 5-to-1 window, this record shows most of the time they have no authority to charge a rate. Now, there might be a scenario in which they can buy down to that window with discretionary resources, but they don't have very many, and you can tell that because they had to put Zone A into the discretionary fund to cover some things. So on this record, both records, and quite frankly, any conceivable record, this agency has no power to do the very thing it was created on an urgency basis to do in 1966. And my opponent...
Not facially unconstitutional.
There's a nuance there that I'm not sure I'm prepared to pursue with you. But let me think about it this way. The legislature said in Water Code Section 74001 that the statute should be broadly construed to achieve its purpose. The purpose here was to keep Ventura's groundwater basin from running dry to the detriment of everyone and every critter that, to quote a recent Supreme Court opinion, that depends upon it. They wanted to do something, and they could not have foreseen in 1966, when I was 5, that the Constitution was going to be amended in these ways. So your choice is to figure out how do you best serve this messy law that you've got. Do you allow this statute to stand, disable this agency and others like it, and hope the legislature will fix it eventually? Or do you do what it seems the legislature intended, which is to give this agency as much power as they could to solve the problem they wanted to solve? Personally, I think it's better for our legal system if we strike that statute down. Judge Anderley, who's crafty about standards of review, avoided deciding on a basis that would set him up for reversal. And so I think he sidestepped it. But I'm not sure he did it in an entirely intellectually satisfactory way. I think that's the best answer I have for you.
Does it matter whether we're looking at this question through a Prop 218 lens versus a Prop 26 lens? Where's the allocation requirements under Prop 218 are just across-the-board requirements. Under Prop 26, there's no requirement. There's nothing that says that a particular fee or charge is unconstitutional if it doesn't satisfy the fair allocation requirements, just a tax, and so it requires voter approval. How does that principle square with, or how does it relate to this question of the constitutionality of the 3-to-1 to 5-to-1 ratio prescribed by the Water Code?
We would like to think there's a distinction between saying it's a tax and it's not unconstitutional, but there never is. The reason that there never is these cases come to you having been adopted without voter approval, and therefore, if it's a tax, it's unconstitutional.
But I think the question would be for the district going forward, what is it supposed to do? Is it supposed to sort of begin by proposing charges that are based on the 3-to-1 ratio and seek voter approval, or is it to be freed from that requirement altogether?
They begin by defining the program they want to provide. That's a legislative choice within a range of discretion. And by determining the reasonable cost to provide that service. And then they allocate those costs among their customers in a fair and rational way. That's the process. What am I doing? What does it cost? How do I spread? And then they discover, am I in the 3-to-1 to 5-to-1 range or am I not? My sense is they never will be. They certainly aren't on either of these records. And they haven't suggested to you in 2 years of briefing this to 3 courts what evidence they could produce that would show it. And think about it. How is it differ if you're growing acres of tomatoes from when you're growing a plot in your backyard? The M&I class includes backyard gardeners. It includes golf courses. It includes nurseries. And you've got farmers who grow tomatoes, actually berries mostly in this marketplace. It's the same function. It responds to the groundwater table in the same way. It uses water in the same way for substantially similar purposes. Now, it's true, the M&I class also produces a lot of flow to the wastewater treatment plant and out to the ocean, and farmers don't do that so much, but they do some because they drain wetlands in order to make the land productive. So there are differences here, but not so many as you might think. And therefore, unless they get really, really lucky or really, really creative, they're not going to land in that sweet spot. Why? These numbers were chosen politically in 1966 to give farmers a break because it was viewed as necessary. And I'm not trying to chase farmers out of Ventura County. I'm trying to make sure they pay their fair share and that the constituents of the city that I serve don't pay more than they're required to. So I think you end up in a place where they have no authority at all. They don't have the statutory authority to tax. They couldn't put a tax on the ballot and say, voters, please approve it, unless what you say is it's not a tax in the traditional sense. They have the power to do this. The Constitution says the way they do this is to put it on the ballot. But if you do that, there's some sense there. You can end up with a lot of mechanical questions that are unanswered.
So in your estimation, counsel, what would have been a legally valid way for the district to get as close as possible to what you take to be its goal?
There are 2 tools available to the district. One is that fairness is a range, not a point. So when you fairly allocate costs, you go as close to the farmers as you can get without getting chalk on your toes. Secondly, you use discretionary revenues to underwrite the favored class, and they have some. And thirdly, maybe you appeal to the legislature or the voters. If the voters want to subsidize a greenbelt around Ventura so that Ventura doesn't start to look like Orange County, and I suspect they do, that's why I had the SOAR initiative, the voters might very well tax themselves to pay for the privilege. But government can't decide to do it. And to put a fine point on it, a board dominated by farmers can't decide to do it at the expense of non-farmers, which is what's really going on here. That's why this agency has a hard time being intellectually honest and consistent about allocating Zone A to Zone B, because anything that goes in Zone A is other people's money. Anything in Zone B is farmers' money, and they know it.
So can I ask you to clarify that answer? So you're saying in order for the Water Conservation District to meet its legislative mandate to maintain and repair these aquifers and this diminishing groundwater, they have to either use discretionary funding, that is, go to the legislature and ask for additional funding to augment its water conservation budget for this purpose, or put it to a vote? And how do you do that?
Not my answer at all. He said, if I want to favor farmers, how do I do it?
I don't want to know how you favor farmers.
If you just want to cover your...
I want to know how do you fulfill the mandate of the Water Conservation Districts when property revenues have diminished?
Every one of these constitutional provisions, 13, 26, 62, 218, and a proposition to be named later, all of them allow you to recover all of your costs. You can cover every last cost. Griffith says very plainly, one of the issues in Griffith, although it's not apparent on the face of the opinion, is they tried to run a line over the mountains into the Central Valley to deliver water. It didn't work. They'd spent tens of millions of dollars and then abandoned it. And they recovered that stranded debt from the current fee for future services. And the Griffith Court said, not a problem. You're not constitutionally entitled to perfect water service, perfectly efficient water service. You're entitled to reasonably efficient water service, and you're entitled to pay for what you get for it. You can recover every last penny of your costs. The question is, how do you allocate? You cannot recover every last penny of your costs at the expense of a disfavored customer class without a rational basis to show that they're paying no more than their fair share. That's the issue. It's not how big the pie is. It's how you slice it.
So in how you slice it, you're saying it has to be sliced under 218.
Well, I think 218 provides the answer because it's really disruptive to the law to say 26. But even if it's 26, you still have the proportionality test and the no free rider test.
So it's not impossible, but you acknowledge it would be quite difficult in a situation when we're dealing with groundwater and interconnected basins, which makes it really difficult to try to say this fee comes from, this water comes from this basin and therefore belongs to this parcel.
Here's where I think a court stands on that issue. These are record cases. Legislatures make choices about how to structure programs and fees. And provided they act responsibly and reasonably and logically in light of their record, they can do what they want. So in the Pájaro case, we had evidence that everything seaward of the San Andreas Fault is a common pool. And therefore, they had a flat rate for everybody who got non-delivered water, meaning water through the groundwater table, and a supplemental rate for people who got piped water. Those are completely rational decisions. This agency only decided after they lost in the trial court that they had a common pool. They made up a common pool when there's years and years and years of hydrogeology showing 8 distinct basins. There's this lovely chart in something they call their rate study, which demonstrates the Mound Basin gets no benefit from water that's released from Lake Piru.
But it would make a difference if there were a common pool.
Correct. And if they had a satisfactory record basis, you would have some obligation under Fukuda, and the trial court would, to defer to those findings. But when there's no evidence in the record, you say there's no evidence in the record, and we don't. I'll give you an example. It's very common to operate a dam, to impound water and then deliver it. And you can't operate a dam without a FERC license. And you can't get a Federal Energy Regulatory Commission. And you can't get a FERC license without recreational benefits. So I'm perfectly prepared to concede that the recreation concession at Lake Piru is a proper cost of water service to Ventura on an appropriate record. But this is not that record. There's no mention of a FERC license here. There's no mention of why they chose to run a concession at Lake Piru. So I would hate to see a decision from this court say that these concessions are general benefit because they're recreation. I would much prefer to see an opinion from this court that says this record doesn't sustain it. Another record might. That's the problem for them, is they can't.
Can I return you, counsel, to the first part of the discussion and get a more more general answer about what are the merits of proceeding under 218 versus under 26? What is at stake, do you think? You seem to suggest that we would do more damage to the law by, in your view.
Yeah, I think there are substantial reliance interests here. There are cases involving the Water Replenishment District of Southern California, which covers the LA Basin, this agency, which covers Ventura, the Great Oaks case, which covers the Santa Clara Valley. There's a case that settled out of the 3rd District that involved the North San Juan Key Basin. And then there are other cases as well. There's been 15 years of law saying that groundwater agencies are subject to 218. If you unsettle that law, we end up having to re-examine all of these cases under Prop 26. And I'm not sure what benefit you get by it. The standard is not all that different, and you're on a record that can't survive either test.
But do you think we've concluded something that categorical? Because I understood you now to say groundwater agencies are subject to 218, and not they're subject to 218 because they are engaging in activities that are subject to 218. So do you read our precedent that categorically?
And it is too categorical to say that the agency itself is subject to 218. 218 applies to a revenue measure, not to an agency.
Correct.
But groundwater charges that are used to augment a groundwater basin and collected in the form of what's colloquially known as a pump tax are subject to 218 because the precedents say so and Sigma says so, and I don't see what justifies such a breach from stare decisis, because you end up with a Prop 26 analysis which takes you to largely the same place.
And if we were trying to generalize that principle, so they're subject to 218 because those particular levies are property related. So property related, coming back to the very first question, means what in general principle?
Amrine chose on a blank slate to treat groundwater, water delivered for domestic use via a groundwater table, the same as water delivered for domestic use via a pipe. And the reasons they did is they saw no basis in the Constitution to draw a distinction. You could argue that. They think the Constitution should have one meaning throughout California. I think that's right. And they think that operating a well so you can live in your house is tantamount to living in your house. No water, no life, no property value. And therefore, this is an essential service. Now, I don't think that means that every water service is subject to 218. Richmond tells you that a water connection fee is not. The case out of the San Diego County Water Authority versus Met, which is pending petition for review in this case, tells you that we've been applying Prop 26 to wholesale water charges. I also think there's a fair argument that may come to you in another case that when somebody's consuming a whole lot of water and therefore pays a larger rate for it, the Capistrano facts, that that's not a property-related service because you don't need to waste water to use your property. So I'm not saying it's everything.
I just don't, I want to interrupt you only to say you'll have 2 minutes for rebuttal if you care to save it.
I will reserve time. Thank you.
Good morning, Your Honor. Cheryl Orr on behalf of the United Water Conservation District and its Board of Directors. The present and future well-being and prosperity of the state depends upon the conservation of life-giving waters. These words spoken by this court in 1933 are no less prescient today. The problems of overdraft and seawater intrusion are ever more dire. The conservation of the groundwater of the state is an imperative. This court should clarify the law applicable to local agencies like the district, to whom the police powers of the state have been delegated by its Enabling Act, to allow those agencies to perform their mandate to conserve and preserve the groundwater for continued future use.
Counsel, does
really
Prop 218 apply?
Prop 218 does not apply to these pumping charges.
Because?
The rule of stare decisis should not be invoked to address a case that has not been decided before. The groundwater pumping charge in this particular case is governed by Prop 26. The court in Paro didn't have the benefit of Prop 26 in deciding its issues. What this court has to do is recognize that there's a progression. We have Prop 13, we have Prop 218, and now we have Prop 26. The court in Paro 1 and the court in Paro 2 and the Great Oaks case did not address the overlay of Prop 26 and what it means for the evolution of the law.
Can I ask you the same question that I posed to your friend on the other side,
Yes.
which is, from your perspective, and given the sort of the focus of the debate in this case is on the calculation of the amount of the pumping charge, what is the difference between the fair allocation requirement under Prop 218 and the fair allocation requirement under Prop 26 in your view?
Well, I don't want to steal my colleague's thunder because she'll be addressing the issue of Prop 26, but there are more stringent requirements in terms of the cost of allocation imposed under 218, and that's why this is so important, because if you look at the decision in Richmond, the decision in Richmond stated that all water fees are not alike. You have to look at what the purpose of the water fee is, and I think that the definition of property-related service is given to us by virtue of the words contained in Prop 218 in Section 2H. It's defined as a property-related service means a public service having a direct relationship to property ownership. So in 218, the cost of service requirements are imposed upon a strict parcel-by-parcel basis. In Prop 26, you do not have the same strict parcel-by-parcel allocation. There is a more flexible allocation of costs and a more reasonable, the regulatory standard from Sinclair Paint is engrafted in the language of Prop 26. And so there is a more flexible requirement for deciding what is fair, what is reasonable, and what should be allocated under Prop 26 that is not contained in Prop 218. And I think the imprecise fit of these charges to Prop 218 is important because, as my colleague noted, the ability of a district, like a conservation district in this case, to actually apportion the benefits of their recharge activities on a parcel-by-parcel basis is not technologically feasible.
Can you tell us why? I realize that these, as I've read, the groundwater basins, these aquifers that are drying up, they're interrelated. So can you explain why it is the 218 property-related or property service doesn't work under the facts of interconnected groundwater basins, parcel to parcel?
Well, the services the district provide are not direct services. It's not that we're providing the water. We're not piping the water to the homeowner or a well owner that's using it. The groundwater exists. The groundwater is there. So this is not a property-related service like the delivery of water in Richmond. So the taking of the Richmond decision, the taking of the Bighorn decision, I misspoke. Bighorn only decided that the water delivery service in that case was a property-related service. And the equation of the district services with the delivery of water through pipes is not a fair analogy because creation of dams, spreading grounds, recharge facilities, the hydrogeology is so complex. You don't know how the water spreads directly to each property or parcel of property. Plus, it is not each parcel or property owner who is extracting the water. The extraction facilities are the source of the tax. The extraction is on the production of groundwater from water-producing facilities registered within the district.
But on the other hand, we do know from our series of cases, including most especially Bighorn, that Prop 218 was intended to cover services that are necessary to the enjoyment of and use of property, and water is certainly such a use. And we know from Pajaro Valley that there are many areas in California where this is how people receive water for use on their property.
On this record, the majority, a substantial number of the extraction facilities are not for domestic or private use. But I think that is an important question because I think if you look at the purpose of enactment of Prop 218. Prop 218 was targeted by homeowners who were fed up with their property tax bills having these added fees and their utility bills having these added fees for services that did not directly benefit them. That was the target of Prop 218. The target of Prop 26, that was regulatory fees. But in enacting Prop 218, they were talking about things that didn't benefit them. That's why they asserted and agreed with the language that a property-related service had to have a direct relationship to property ownership.
But why wouldn't the citizens that complained and pushed for 218 have the same complaint here?
They weren't complaining about water, groundwater, or the right to groundwater. They didn't speak to that. They talked about sewer, refuse collection, and water delivery. It is much easier to say, I can allocate the cost of driving my truck down the street to pick up the sewer from an individual homeowner on this street or to pick up the waste from a farm located in another area. You can directly identify the cost to that service and to attribute it to that parcel. We're talking about...
But under this fee, they're paying for the exact amount of water that they're pumping.
They're paying a fee for the exact amount of water they're pumping, but the cost of the district-wide services that the district is providing is utilized in a manner that you cannot attribute its cost on a parcel-by-parcel basis because you can't follow the water. And it's a dynamic situation. Hydrogeology changes. Because we're having these overdraft and long-term overdraft problems, we're having subsidence issues. So the geology is constantly changing. So that's one of the other problems with determining what recharge facilities work, where are they going. But I did want to...
Council, what about landfill maintenance? Your opponent on their side cited landfill maintenance as an example. Is that easily traced to particular parcels?
Well, I think if you could determine that the amount of trash that is brought to a landfill by someone who's delivering the landfill, you can determine, it wouldn't be determined on a parcel by parcel basis. And I'm not sure that would actually be as an incident of property ownership if you're actually going to a facility that is a specific offsite landfill. I'm not sure that you as a property owner are receiving a direct benefit from that public utility. But I think that the property ownership issue, I wanted to go back to that because I think it's very, very important that groundwater pumping here is a voluntary act of conducting an operation on the property. The fee ceases if you stop pumping. Water rights, whether they're overlying, appropriative, or prescriptive, are all usufructuary rights. The holders of those rights only have the right to use the property of another. The another, in this case, is the state. The state owns the groundwater under Water Code Section 102, and also by virtue of Article 10, Section 2, since 1928, the state is constitutionally mandated to conserve the groundwater and regulate it for all users and for the public health. So since 1928, actual groundwater rights are founded in the state as a matter of constitutional law. So with respect to 218, when you go back and you look at what did 218 intend to serve, it intended to serve the rights of people who owned their real property and the rights of people who got their utility bills to say, I'm only going to be charged for what I do on my property, not just because I own my property, and what I receive from a public utility as a benefit and not anymore. Now, the overlay is when you read Prop 218 and pari materia with Prop 226, you realize that there was a progression, that they weren't targeting regulatory fees when they enacted 218, but then they found that the use of regulatory fees and judicial interpretation of the right to impose regulatory fees created more taxes and more fees. And so then in Prop 26, they decided to target these additional fees and say that now we're going to tighten up what can be imposed as a regulatory fee, and these are the particular exceptions. And I think that the use of the, I don't want to, again, steal my colleague's thunder because she'll be talking about 26, but I believe that you need to look at that progression, and that analysis was not made in Pajaro 1, Pajaro 2, or Great Oaks.
Can I ask you to take us through an exercise briefly of if we were to determine that these groundwater pumping activities were in fact property related or a service incident to property ownership, how would the Water Conservation District go about imposing fees for this service constitutionally?
Well, we attempted to introduce in the trial court in Phase 3 a cost of service analysis that did attempt to justify the 3-to-1 ratio in between the ag and M&I users, but the trial court declined to take judicial notice of that. The water districts would do what they needed to do, but they would be constrained to follow Water Code Section 75594, which dictates the 3-to-1 ratio. And if the court found that they were required to comply with Prop 218, they would have to comport with the cost of service requirement and make this.
A response to your friend on the other side who says that on this record, you can't justify it.
Well, I think he's taking license with the record. I think that the trial court rejected the notion that Zone A charges were being, or Zone A funds were being used for anything but Zone A charges, and that it was appropriate to have a second Zone B fund relating to specific services in that smaller Zone B. And the findings were supported JAE 2139 with respect to the Zone A and Zone B charges, and the court noted that the budgeting for the district confirmed that they only budgeted Zone A funds for Zone A charges. So the argument that was made in the trial court by the city that there was this commingling was rejected on the evidence that was presented in the trial court. There was no commingling of funds, and even though they denominated it a general fund, it was not a general fund. It was only used for Zone A expenditures.
So when we've talked about the constitutionality of Water Code 75594, we've talked primarily in terms of whether historical data can justify allocation of cost under Prop 218 in accordance with the 3-to-1 or 5-to-1, but here 3-to-1 ratio. But going forward, is there just sort of fundamental incompatibility between the standard that Prop 218 calls for and a directive that calls for the allocation of costs on some basis other than the proportional cost of service, if that's the framework we're operating under?
That is why I believe our court looked at the specific language of Prop 218, Section 6. My colleague indicated that the language couldn't be satisfied, so it should be more flexibly interpreted. Well, this court should actually interpret the language of 218, a constitutional provision, according to the words that are used. And this imprecision or imprecise fit and a disconnect between the groundwater pumping charge and the service that it provides to the basin and the service that it provides to extractors of providing a managed basin that provides water for continued use is not the same service as a public service, a public utility providing a property service to a real property owner.
So let's even take as a given your argument that Prop 26 is the right framework instead of Prop 218. There is still a fair allocation requirement under that constitutional provision. So how does any kind of constitutionally required fair allocation requirement comport with the 3-to-1 ratio called for under the Water Code?
Well, I believe that if you look at the qualitative as well as the quantitative benefits from agricultural use, that a district could convince a court that the 3-to-1 ratio is a fair and reasonable allocation.
What is the qualitative benefit, counsel?
Because agricultural use is used on the property and it recharges the groundwater. It percolates back into the aquifer.
That would just mean that the statute is really doing no work, right?
I'm sorry, I didn't
That
hear.
would just mean that the statute is doing no work, because the fair allocation requirement would have already justified the 3-to-1 ratio. The statute's only doing any work in situations where the fair allocation notion is not otherwise satisfied, and that the statute then has bite in those situations where 3-to-1 is being mandated over and above any kind of fair allocation. But because the fair allocation is a constitutional requirement, how could that water code stand in any situation where it does any work?
Well, I think that the allocation an allocation between ag and non-ag or M&I users is not incompatible with Prop 26. You can...
What would that scenario be?
Because the legislature has declared that it is fair to attribute agricultural use to or subsidize agricultural use for the sake of the economy. And that legislative decision has been made, and that is a policy decision that has been made by the legislature with respect to agricultural use.
Is that a constitutional construction by the legislature of what a fair allocation is?
No, I don't think so, but I think that the words of Prop 26 give the legislature the ability to think through these qualitative differences between users to make a different allocation.
I gather what you're saying, counsel, I gather, you can tell me if you're saying something different, is that while we must ultimately give effect to constitutional provisions that call for apportionment, for example, and to weigh benefits and burdens, something about what the legislature does in the course of legislating should inform our understanding of what counts as a benefit and what counts as a burden.
That's true, because the legislature has made some type of informed decision that has not changed since 1965 or 68 when the Water Code was enacted, that there should be this adjustment in the water rates and this differential in the water rates to favor agricultural users.
But will you then concede at least that there would be some allocations that would involve a 3-to-1 ratio, a 4-to-1 ratio that would simply not be constitutional? In other words, even if the legislature had been taken seriously in its own gloss that it put on the notion of a benefit, there would be some instances where that would not be enough to justify the ratio.
True. But each case would stand on its own record and its own cost of benefit or cost of service analysis that is undertaken under 26, and with the overlay of 75594. In this case, we didn't have a choice. The district had to comply with that mandate. And we didn't have a constitutional, we couldn't avoid the Constitution and not apply a statute that this court has not struck down as unconstitutional.
That's something that, is there something you would have wanted to do differently?
They've been operating under the statute for, I think, something like 37 years, and it's been their guiding principle in terms of rate making. The problem is the proliferation of Prop 218 cases and challenges threatens to undermine, if not destroy, the long-term ability of these agencies to engage in rate making. They engage in rate making every year, and they're faced with these cost of service challenges under Prop 218. And the fact that Pajaro has been on the books for 8, 10 years, whatever it is, doesn't mean that it's right, and doesn't mean that these districts should be jumping through the hoops of Prop 218 when we know what the intent of Prop 218 was. There's a separate constitutional provision under Prop 26, and we can meet the exception to Prop 26 that isn't the property-related fee exception of Prop 26.
In the Sustainable Groundwater Management Act, the legislature did decide to impose the requirements of Prop 218, at least on certain groundwater management districts, didn't it?
I think the legislature did that to provide some guidance for the agencies that would be set up under SGMA because of the existing case law, because of the Pajaro line of cases, and the notion that if you have some case law out there that says that Prop 218 is governing your rate making, the legislature can't do anything about that if it's not constitutionally permissible. They can't override that decision. So what they have to do is they have to legislate, give their agencies that they're formulating some guidance of what to do. And they made two choices. You can follow Prop 26 if you're a sustainability plan, creating a sustainability plan. But if you're engaging in groundwater management, you would follow the Prop 218 path. But sustainability programs include some of the same abilities or powers to create facilities, acquire land, do all those things. So I think that there's still flexibility under SGMA for those agencies created under SGMA to engage in their rate making subject to Prop 26 and not subject to Prop 218.
Ms. Orr, your time's expired.
I'm sorry.
Good morning, Chief Justice, Associate Justices. Welcome, Justice Urian. My name is Jane Usher. I had intended to talk about Prop 26 and how fundamentally different it is from Prop 218. You have already asked some of those questions, and I don't want to presume that you don't have the answer.
I would still like to hear about that.
Very good. When I read the Pajaro line of cases, and I called them Pajaro 1, Pajaro 2, and Great Oaks, I was struck by the disconnect, as my colleague Cheryl Orr has mentioned, between the statutory language, the constitutional language of Proposition 218, its procedural mandates as well as its substantive mandates, and those decisions. As I read those cases, I felt like the judiciary was doing judicial backflips. There was confusion. There was speculation on the part of the court to make a Proposition 218, fit groundwater, distinct from domestic water delivered to homeowners through pipes. I felt like the court was trying to shoehorn factual circumstances that were inapposite. So we started Prop 218 with the notion set forth in Apartment Association that the action of the property, the action of the fee, has to be as an incident of property ownership, which they indicate to us is by virtue of property ownership. Nothing more needs to happen, and you will be charged. That isn't this case. That isn't a groundwater management case.
I mean, but we have gone beyond that.
So you're referring to Richmond and Bighorn?
Yes.
But I think Bighorn only took you to this point. I think Bighorn only took you to the point that water delivered by a public water agency for domestic purposes through pipelines is as an incident of property ownership. I don't think this court has ever looked at groundwater and groundwater management, conservation, protection, and augmentation, and equated that with the delivery of water domestically through a pipeline.
Could you clarify for me on this record, does the city operates a number of wells?
Yes, it does.
And those are not solely for domestic use, are they?
How,
or are they not? I guess.
How the city uses it, I believe that the city uses some of the water for its own purposes, and I believe it acts as if you will, as a wholesaler, as a retailer, and it sells it to its urban customers. So I think it does both.
Mm-hmm. Is there some way to figure out how much of the water is being sold or channeled to property?
I believe that would be discernible. Yes.
I guess it's kind of hard. I agree with you that Bighorn is not directly, squarely on point, but it doesn't seem a huge step to say, well, okay, ongoing service to property is a form of property-related service, but the next step is just, well, what is the precondition of that?
I understand your discomfort, and here's how I think about it. When the city does whatever it does with the groundwater that it extracts, and of course, that's not United Water District's obligation to monitor or record. The city's obliged to record the water it extracts, and it is not obligated to tell United what it uses that water for, only the volume. The city then has a relationship with its customers, the urban dwellers, and that relationship and that rate setting has its own set of protections, constitutional protections. And I think what you have to do is you have to say, United has a mission, a purpose, it's groundwater preservation, augmentation, conservation. The city has a different purpose, and the city will follow the constitutional mandates of rate setting as it relates to its own customers.
So, Ms. Escher, before you run out of time,
I'm so sorry.
I understand that you're going to talk to us about Prop 26.
Yes.
So can you tell me why Prop 26 fits this kind of case of groundwater and pumping activity of the groundwater versus 218?
Very good, Your Honor. Where we find ourselves with Prop 26 is voter discontent over hidden taxes, the blurring of lines. What's a charge? What's a fee? What's a tax? They came up with what I'll call the omnibus solution. Everything is presumptively a tax unless it meets one of the 7 enumerated exceptions. We have an exception, it's E1, and it fits so appropriately the factual circumstances of what United does and the benefits and the burdens of the city. It fits like a glove. I referenced earlier the Prop 218 judicial backflips, one of which is...
So why does E fit?
Because E1 says you are not a tax if you provide a specific benefit or privilege, and you don't charge for this specific benefit more than the reasonable cost of your governmental activity. So I consider the groundwater. We've talked a little bit about how the Santa Clara River, but for the activities of United, that river water would be lost to the ocean. It would not necessarily be recharging the aquifers. That's United's job. Protect those aquifers, recharge, divert. So we have United engaged in this district-wide service of protecting the groundwater. And along comes the city, and not just the city, a number of pumpers. They're well operators. They make their own facilities. They make their own choices. They're required to register. They may not pump unless they register. They may not pump unless they pay the pumping charge. They are receiving that benefit, the benefit of being able to pump. And when they do pump, there's going to be groundwater for them. And that groundwater is going to be present. It's going to be of a quality that United protects, preserves, conserves, augments.
What about the fair, reasonable relationship requirement?
Very good. Our Court of Appeal thought, and I agree with them, that Sinclair Paint and California Farm Bureau tell us how to look at the fair and reasonable relationship requirement. And our Court of Appeal gave it perhaps shorter shrift than this court would like. They said, if you're charging someone for a benefit or for their burden based on the volume that they draw, such that someone who draws more pays far more than someone who draws less, like perhaps that domestic user that you're concerned about, this is fair and this is reasonable. Now, you've let us know, you've signaled to us, thank you, Associate Justice Cuellar, in the Jack's decision of earlier this summer, that Sinclair Paint's reasoning, both on the reasonable costs and on the framework for proportionality, that it be fair and reasonable. And there are other cases earlier that look at this and talk about informed decision-making by the elected officials. Informed, honest, fair, reasonable. These all characterize the activities of United Water, and I don't know if I have any time remaining.
I'm still not clear on one basic issue, which is what Justice Kruger started with, which is what is the difference between this requirement and the Prop 218 requirement?
Prop 218, I've read it and read it and reread it, and I can't see it saying anything other than the cost has to be proportional to the cost of service on a parcel-by-parcel basis. That's what it says. And the fact that the Pajaro line of cases has construed that differently is discomforting to me. I like my constitutional interpretation to be based on what the constitutional mandate actually says. What does it say? So we try parcel by parcel, and Your Honors, if you hold United to that standard, they will meet it, but it will require some creativity on the part of all of the groundwater management agencies. There is a common pool here. There are 8 basins that United protects. Despite what you heard this morning, the trial court held that there was a common pool. And that means that we can't trace a molecule of water in the groundwater the way we can trace it in a pipeline. Why? Because water flows in complicated ways, ever-changing ways. And the scientists and hydrologists and biologists who work at United are constantly challenged to understand the best recharge methods because of the complex hydrology. Pumping in one area, ultimately, and United's mission is a penultimate mission, it's to protect the groundwater into the future. United cannot do that molecular tracing. I think of groundwater like a bad house guest who moves from room to room when you're not watching. And that is how groundwater operates. That's how groundwater works. And that's why, Justice Liu, it is such a challenge mentally for me to understand how groundwater management, conservation districts like United can do a parcel-by-parcel allocation. They'll do it if you require it of them. They have tried over the years to do that very thing. But when I look at Prop 26 and E1, I say, eureka, we are found. There it is. That is what's happening here. United is providing a district-wide service. Prop 218 tells us a district-wide service, you can't do that. There can be no free riders.
So Ms. Escher, your time's expired.
I'm so sorry, but thank you for your attention.
Let me try again to answer Justice Kruger's question. What difference did does this analysis make? The 218 test looks to the cost to serve a parcel or a class of parcels. So what services are they getting? What costs do we incur? 26 asks us whether there's a fair or reasonable relationship, lovely lawyerly or, fair or not reasonable and not fair, relationship between benefits and burdens. The benefit is typically going to be the service itself in a service context, but 26 applies in non-service contexts. It applies in regulatory contexts. So I don't think that the benefits and burden analysis will very often differ from what are we giving you and what does it cost to give it to you. But in some cases, it may. As I try to conceive of a case that would come out differently, this occurs to me. The third exception in 26 is for regulatory fees that recover the cost of regulation. And it was obviously written in light of the San Diego Gas and Electric case, where your permit fee was based on your volume of emissions. I can conceive of a case in which you're charging you for regulation and provide you no service, because we never interact with you, because you never come to our attention as a violator, so we don't address you. So you're not putting any burden on us, so there's no fair relationship to burden, but there is benefit. Because you're in an even marketplace, your competitors are not getting an unfair advantage by not complying with rules that you can comply with. So I think the regulatory example might give us a framework to think about when it might matter. But I think primarily it's just a different thought process that is frequently going to arrive at similar results.
But so your friends on the side say that the primary difference is that 218 requires this allocation be done parcel by parcel. I assume you...
And that is an important difference, but it ends up being practically not very different, because class-by-class reasoning is necessary to make sense of all of this data.
But the generality of the class and how it's drawn matters greatly
sure does.
To the rate-making process.
It sure does. The other point about 26 is that the gateway into this analysis differs. 218 applies to fees on the tax roll and otherwise directly on property and for certain property-related services. 26 applies to everything, but once you're applying one of the exceptions in 26, there are standards to be met. So here they needed to show direct benefit. They needed to show reasonable cost. They needed to show free riders.
And what's missing?
They didn't try to meet this test. They said we provide broad social benefit, and therefore we can't show you any direct service to anybody, and we can't disprove free riders because we're doing health and safety in the environment. They didn't try to prove compliance. They tried to fuzz up the test to the point that anything would pass it.
The term cost is used in both Prop 26 and Prop 218. Do I gather, as I try to process how you've set this out, that you think the term cost in both means essentially the same thing, or it means something different?
I think cost has both an ordinary meaning and a more specific meaning. And the more specific meaning is there are folks who are in the business of cost accounting for government, and they have very sophisticated understandings of how to do cost allocations. And in this record, we make reference to the American Water Works Association's M1 manual, which Griffith said is a good way to do rate making. There are similar ones out there. But cost accounting, there's a lot of people who make a living under that job title. So there is known science here. It's like anything else. It's not going to give you just one answer. This is legislative activity. There's a range of reasonable rates to be made here. They want you to believe they can't account for their costs, but they created Zone B. If they can't account for different costs, why did they create Zone B? It's not all one pool in their own view.
So what I hear you saying is, to the extent that there is any flexibility in how that term cost is defined, it still requires cost accounting and it requires a record.
It requires a record, because reasonable legislative judgment informed by a record. Now, I want to return, if I can.
Your time's expired.
Okay. Thank you.
30 seconds.
Okay, 30 seconds. Your question about why I should persuade you that the statute is unconstitutional. There are flatly inconsistent duties in the Constitution to account for costs and in the statute to ignore them. The Constitution says, notwithstanding any other provision of law, so the preemption here is not implied, it's express. And lastly, you've got a long line of cases showing the breadth of preemption that 13 and 218 do, Ventura Group and Manteca among them. Thank you.
Thank you, counsel. Matter submitted. calling the matter of Alexander Vasilenko versus Grace Family Church. The Honorable Barbara J.R. Jones, Presiding Justice of the Court of Appeal, First Appellate District, Division 5, sitting assigned. Have a seat, counsel, and when you're ready, you may proceed.
Thank you, Madam Chief Justice. May it please the Court, my name is Paul Delormier, and I represent the defendant and respondent, Grace Family Church. Premises liability is predicated upon the concept that possession includes the attendant right to manage and control the premises, justifying liability when one has failed to exercise due care in the management of their property. Those are the words of Justice Ray in his dissent in the Vasilenko matter. They're also from Sieber versus Hotel del Coronado. Now, this is a duty of care case, and we have here the concept in this duty of care that possession and the attendant right to manage and control property triggers the duty only when the holder fails to meet that duty of care in the management of their property. This is a basic tort concept which the Court of Appeal in the Vasilenko decision missed the ball. The Court of Appeal decision must be overruled. It is not only violates this very basic concept, but it is unworkable. We start with the Rowland factors and Civil Code 1714. We understand that everyone is responsible for an injury occasioned to another by his or her want of ordinary care or skill in the management of his or her property. But we have various exceptions which have been clearly supported in the law and restated by this court on multiple occasions that a defendant cannot be held liable for a defective or dangerous condition of property which it does not own, possess, or control. That's from Isaacs versus Huntington Memorial Hospital, restated again in Alcaraz versus Beachy, restated again by this court in Carson versus Facilities Development Company. And we go back to the words of Justice Mosk in his famous dissent in Connors versus Great Western Savings and Loan, that the right of supervision and control goes to the very heart of ascribing tortious liability. Now, there's exceptions to this rule.
Counsel, we have these cases, you know, that impose or find a duty where a mobile business has located in a particular location. Yes. And impose a duty because of that location. So just talk through how you distinguish those kinds of cases in that line of reasoning.
Well, those kinds of cases are the Schwartz versus Helms Bakery is the main case in that regard. We have a situation here where a vendor is selling on the street. The zone of area where that vendor is selling is the area around his truck or around his or her truck. And that is the zone of area that is going to be where the duty is going to arise. When you create, as the Court of Appeal did in Vasilenko, a situation where the condition, we have the church's property, which is abuts a major street, a busy street. We have occasional use of an exterior parking lot, which is also on a busy street. There is nothing of a condition of those premises which cause anything more dangerous on the city street.
When you talk about the zone around a mobile vendor, is that a matter of distance that you think distinguishes the church here, or is it something else?
No, I don't think it can be. It can't be equated with the church, because when the cases of Steinmetz and Navarez and then Owens limited this type of area where you find a traveling business, a traveling vendor, to the situation where it travels because they have control over where they're going to park their truck and sell their goods. This has never been applied to a premises holder who has an area of fixed location where their business works at a fixed location. primarily because it's an unworkable way to equate the duty of care. I think
But doesn't the church have some comparable authority over where it locates its overflow parking?
Well, I think that's a very good question. But the issue there is the church is only going to be able to use a parking area which is available to it. It doesn't really have an ability to pick where it's going to have its parking lot. It's not, the Court of Appeal in Vasilenko made it sound like they could pick and choose where they were going to put their parking lot. That's not going to be the case. And even in a situation of an urban property owner, a downtown property owner, for instance, who contracts with other off-site parking to provide parking for people that come to their business, it would be a very onerous burden to try to figure out a relative safety system whether someone has to cross a busy street. I think it's very important to realize crossing a busy street is not an unreasonable risk of harm. I think in our collective lives, we've crossed busy streets thousands and thousands of times. It happens all the time. It happens every day. Courts in this state, superior courts, courts of appeal, have on their websites where you park your car when you come to visit the court. Oftentimes, those parking lots are not contiguous with the court. People have to cross a public street. They have to cross busy public streets if it's in an urban area. To say that's an unreasonable risk of harm, and to say whether or not a property owner needs to decide, well, whether one has a crosswalk or a signal, the duty has to end when there's no condition on their property creating the issue, creating the negligence occurrence. For instance, in Barnes, we have a property that has a driveway, a steep driveway, a child play area, and a sidewalk. A child is playing there and is catapulted into the street. It was the condition of the premises that resulted in that duty of care.
So you would have us draw the distinction categorically at the line of the owned property of the entity? So what if the church had, 300 regular attendees and 3 parking spaces?
At their own site?
Yeah.
Well, I think that happens often. I think there's churches that have that.
There might be a disparity between attendees and parking spaces, but maybe not so often between 3 parking spaces and 300 attendees.
I understand.
The point simply being, can you imagine at all a situation where maybe the tort-related inquiry would require us to look at the facts and not have as much of a categorical rule saying simply because the particular conduct in question happened beyond the property line, it's simply beyond the purview of our analysis?
Well, I think we have to look at this in terms of a category of negligent conduct. And in the Inoki case, it was a condition, this is a restaurant next to a busy street, and the court found that it was the condition of the driveway on the premises that resulted in confusion to people driving out of the parking lot. But it was a condition of the premises. I think if you get beyond that and you get off the premises, the duty, no case has ever found anything like that for a premises liability, in a premises liability setting.
In this case, did the church increase the likelihood that at least to some extent that church members would encounter harm by crossing the street after parking in the adjacent lot?
No, Your Honor, I don't think so. I think the Court of Appeal in Vasilenko made the mistake of finding that because the parking lot was not next to a crosswalk, that somehow that resulted in an unreasonable risk of harm. But that is not an issue that should be determinative of this issue, because crossing a major busy street is not an unreasonable risk of harm. And have I answered your question?
Yes.
I think further on in reviewing the rules set forth in Rowland, I think in the issue as far as foreseeability goes, we have to think in terms of a category of negligent conduct. In Rowland, the premises holder, it involved a broken faucet handle, which was known to be broken by the property owner, was not readily apparent to a visitor. It's a condition of the premises. In Inoki, once again, I believe that the court found it was a condition of the premises because it was a confusing driveway. In Barnes versus Black, again, it was this driveway that catapulted a child into the street. In Bigby versus Pacific Telephone, when we used to have telephone booths, this was a telephone booth that was difficult to open and resulted in a duty of care to the company, to the phone company, because it was their property that created this duty, this unreasonable risk. In McDaniel versus Sunset Manor, we have a condition where the apartment has multiple children. Next door to that apartment is a creek containing a 7 to 8 foot vertical drop, and all that separates between the children and the creek is an old dilapidated fence with a hole in it large enough for a man to get through. All of these cases involve a condition of the premises. Then you have, similar to McDaniel, Brooks versus Eugene Berger Management, another apartment house where a child runs out into a street. All we have here is an apartment building next to a busy street, and the court found there was no duty to put up a fence or a wall to prevent the children, even though premises owners knew there were children present. In Donald versus California Western School of Law, we have a situation where the school knew there was dangerous criminal activity off the site. But in that case, the school was not held to a duty. They did not provide on-site parking. They knew that the students would have to leave the school and go out into this area of criminal activity. But the court found no duty in that situation. All of these cases require, for a duty to be found, that there has to be a condition on the premises triggering this duty of care. I think that one of the issues that is raised by my colleagues is the control argument, where the Court of Appeal spoke to the issue that somehow the church was in control of the area off the site from the parking lot. This is a very seductive argument. The church did not own this lot. The church did not have any type of formal rental agreement for this lot. The church had temporary use of this lot as a parking lot, as an overflow parking lot. And during this temporary use, the plaintiff was injured because he crossed the street during the conditions that occurred. However, in an urban setting, having an off-site parking lot is not an unreasonable risk. And unlike Schwartz versus Helms Bakery, which involves a traveling street vendor, this is not a situation where the church can move the parking lot from one area to another. Another case that the court deals with below is Bonanno. In that court, the court actually came to the realization that in Bonanno, that case, which involved a question of a dangerous condition of public property, whether the location of a bus stop was a dangerous condition. And in that situation, we have the court stating that they were more like Schwartz versus Helms, and it involved a situation where the bus district could move the bus stop. Moving the parking lot is not something that's readily available to the church. And the other issue I think that's important about Bonanno, because the Court of Appeal relied on it to such a great degree, our case is a duty of care case. And the Bonanno case involves a condition of public property based upon the statute. The analysis of whether something breaches a duty of care is not the same as one whether a dangerous condition of public property exists. And I think that Justice Werdiger, in her decision in Bonanno at footnote 4, makes it clear that the analysis of a dangerous condition of public property is not the same analysis. And she states there, the principle at work is not that property owners must ensure the safety of all persons who encounter nearby traffic-related hazards in reaching their property. That was the condition that Justice Baxter discussed in his dissent. But that public entities are subject to potential liability not as insurers, but for their own negligence, and not as a matter of common law, but by mandate of Section 830 and 835 of the Government Code, when their facilities are located in physical situations that unnecessarily increase the danger to those who, exercising due care themselves, use the facilities in a reasonably foreseeable manner. The indication being the analysis of a duty of care of a premises liability case is not the same as whether or not someone has violated the Government Code.
I noticed on the map in the record that there is apparently a church parking lot.
Yes.
Across catty-corner from the church, across route.
It's I believe that it is it's a lot. It's another private lot owned by another commercial lot, which the church.
Not owned by the church.
Not owned by the church.
Mr. Laurier-Millet, your time's expired.
Thank you.
My name is Eric Borston from Horvitz & Levy for Defense Amici. And I have a couple of points to make to start out with, and I also wanted to address a couple of the court's questions. One point I wanted to make is that California should not become an outlier when it comes to recognizing duties to protect against dangers off of a premises owner's land that premises owner did not create or control. And I know the briefing cited a lot of out-of-state cases that went to this. And I just wanted to emphasize that it really is the minority view that a duty could exist here. And it's a minority of one, just the Warrington case out of New Jersey that my colleagues on the other side cited. Warrington is an interesting case. There was held to be a duty for a restaurant to provide safe passage across the street to its parking lot. The interesting thing about Warrington is that it was a direct result of a 1981 New Jersey Supreme Court case that held that there was a duty for a business owner to repair a sidewalk that abutted the business owner's premises. That's the opposite of what the law is in California, as recognized in Sexton 65 years ago, which cited Martinovich, which was from 1900, which then cited the common law, which preexisted that. So for over 100 years in California, the rule is a business owner does not have a duty to remedy a danger, even abutting his property, that the business owner did not create or control. And that's the rule that businesses in California have structured their expectations around. That's what they've set their prices based on. That's what they've structured their conduct based on. That's what governments have structured their conduct based on. I don't hear plaintiffs in this case asking for a departure from that rule. But a departure from that rule is the only thing that gets you to liability in this case. That's why the New Jersey court said that there was a duty to ensure safe passage to a restaurant's parking lot based on that New Jersey Supreme Court case that is opposite from California law. On the other side, the side that California should choose to continue to be on, you get Davis out of Massachusetts, Ferreira out of Rhode Island. You have those are the highest court cases there. Then you have the intermediate appellate court cases in Illinois, the Sweat case, North Carolina, Lauman. You have New York, Ovechina, and you have Georgia, Walton. All of these cases recognize that there's no duty to ensure safe passage across public street, even if the property owner somehow influences people to access its property through a certain way.
How do you distinguish the Bonanno case?
So the Bonanno case, I think, was an application of the Schwartz case that Cuellar was alluding to before. The city or the bus authority really could locate that bus stop anywhere. It was akin to a mobile business. You could put one place, you could put another place. You're not linked to a premises that's in one place that's owned or controlled by a landowner. And if you look at Schwartz and how courts have applied Schwartz, going back to your question, it really is cabined to the situation where a business is mobile. So a truck can go anywhere. So if you look at Navarez, Owen, Steinmetz, Sieber, Donnell, in all of those cases, there's some amount of control exercised by the defendant over the possible means of ingress or egress to the property. So in Steinmetz, they held a business mixer in a dangerous area of town. Well, Steinmetz could have picked a different industrial park to hold the business mixer. That doesn't make it a mobile venue subject to the Schwartz line of cases. In Sieber versus Hotel del Coronado, you had an entrance, but maybe the hotel could have closed that entrance or opened a new entrance, or warned or put signs directing people not to use that entrance next to the dangerous crosswalk. Something that might escape attention a little bit is in Donnell versus Cal Western, the plaintiff actually parked on a faculty parking lot owned by the defendant, Cal Western. So you have a very similar situation to here, or even, I guess, more of a connection to the defendant, because the plaintiff parked on a parking lot owned by the defendant, crossed public land to then get to the other property owned by the defendant. Now, it really wasn't an issue, the fact that faculty lot was owned by the defendant, because for whatever reason it didn't come up in the decision, but those facts are not reconcilable with holding liability here.
So would it be appropriate for a court to, in deciding the existence of a duty of care, to look into the other options that might have been available for parking that might not have required crossing a busy street? So if the record showed that there were 3 other available parking lots on the same side of the street within a 3-block radius, is that relevant to the inquiry?
Your Honor, I think at the level of generality required by Cabral, it is not relevant. Anytime a business chooses a parking lot, you can imagine that there's some parking lot twice as far away that maybe has a slightly different safety characteristics for approach. So if you don't want to impose a duty on a business owner to, you can choose the lot across the street that's across a busier street versus a lot 3 blocks away that requires you to hop over 3 unremediated cracks in the sidewalk and is dangerous from that direction. Or that a certain group of people hangs out south of the business and they don't hang out north of the business, so you shouldn't choose a parking lot south of the business.
I gather, counsel, your point is that there's some value in discretion and in not micromanaging the choices of the entities that are being regulated by tort law. But in Kessner, we reaffirmed something very familiar in tort law, which is that the core premise of tort law is that we ought to look for those parties that are best situated to prevent injuries and incentivize them to do so. How is that purpose served by a categorical finding of no duty here?
Your Honor, the person best situated to avoid this injury is the pedestrian. That's the person that knows how fast he or she can move. That's the person that can assess the visibility. That's the person that can assess the traffic flow at any given situation. I know in this case it was alleged that the fact that it was raining made a difference. The fact that it was night made a difference. to put that burden on the business owner to choose a parking lot that works in all sorts of different situations to for any type of foreseeable pedestrian is, I think, an unworkable burden. People are used to crossing streets. People are used to assessing traffic. People are used to deciding for themselves what level of risk.
Sure, but let me channel a version of Justice Kruger's question. Let's suppose that I agree with you that that's true in the typical busy street scenario, the typical parking lot situation, the pedestrian, the driver, better positioned to prevent harm. But might not there be some streets, exceptionally dangerous streets, specific circumstances where that would not hold?
Your Honor, I could see as a factual matter, yes, there might be some factual circumstances where that would hold. I don't think that affects the analysis here. Cabral requires that we analyze the decision whether to create a categorical exception to the duty rule at a relatively broad level of generality. And that presumes that there might be some factual cases where if you were really looking at the individual facts of every case, you might think it's more fair to have liability, and the categorical rule says no liability, and the converse might also be true.
I think that Cabral is important, but it does sound to me like a core part of your argument here turns on that word relatively broad, relatively general, and just determining exactly how broad or general it should be in this particular circumstance.
I agree that determining how broad or general it should be in this particular circumstance is a very key question, and I just urge the court to follow the part of Cabral that says you look at it at a relatively broad degree of generality, and if the rule is, in circumstances where it benefits the plaintiffs to pick out every single, unique fact to the case, that's just as irrelevant as the situations where it benefits the defendant to pick out the unique circumstances about how this particular injury wasn't foreseeable, and that just the Cabral rule be applied consistently and try to achieve a uniform level of generality no matter who might stand to benefit.
As a follow-up to Justice Kruger's question about the 3 parking lots adjacent to the church, I questioned your co-counsel about the parking lot that's catty-corner from the church. It's very small, but it looks like it says parking for senior pastor and church administrator. Is that an alternative parking for church parishioners?
Your Honor, I don't recall anywhere in the briefing any side urging that particular tiny parking lot to be relevant to this case.
I know on the map that there's a street in the rear of the church that says no parking on the streets. Is there parking on Marconi on the street?
Your Honor, I don't know the answer to that question.
My question would be, if the plaintiff parked on the street on Marconi and crossed the street and was injured, would it make any difference?
Your Honor, it shouldn't make a difference. If the plaintiff chooses to park on the street on the other side of Marconi, the plaintiff would have to cross the street. It shouldn't matter that plaintiff parked in a parking lot that was controlled by the church. The fact that the church controlled the lot did not increase the risk to plaintiff 1 iota. I know that the line plaintiff wants to draw in this case to prevent this from being an amorphous duty that just expands without limit is they say it only applies when the defendant controls the parking lot. Well, that control didn't have anything to do with plaintiff's risk. Crossing Marconi would have been just as safe or not safe no matter who controlled the parking lot. So that's why I think it follows, just as there's no duty to assure safe access for someone who chooses to park across the street on the street, there's no duty that's created by this fact of control, where the fact of control didn't actually increase any risk.
Mr. Borstein, your time's expired.
Thank you, Your Honor.
May it please the court. The crucial point in this case is that this duty that the court is considering to use ordinary care to provide safe passage is not one that flows from any sort of obligation of the defendant to maintain the street or control the street or any other property that belongs to a third party. And the plaintiffs don't contend that the defendants have that burden. Instead, this duty flows from the defendant's obligation to use ordinary care in the management of its own property under Civil Code Section 1714A, because how a defendant manages its own property can unreasonably increase the risks to persons on adjacent
When you say
properties.
manage the property, that includes siting.
That includes where the location of the property, and in this case would include where it chose to establish an overflow parking lot despite its knowledge of the extreme danger of crossing from that lot to its premises and vice versa, and also in continuing to use that lot at certain times when it didn't have to use that lot. It had discretion to open or close that lot whenever it wanted to. And also in terms of location of its overflow parking, as discussed during the argument of opposing counsel, there was choice, there was control of the defendant in where to locate its overflow parking. It could be moved.
So, Mr. Toronto, I have to have a question with the focus of the parking, because I understand Mr. Vasilenko was hit in the street.
Correct.
And it's raining. So under my view is he parked his car and then he chose during this rainy night in the dark, he chose to cross when he chose to cross. He looked at the traffic, he made an assessment, he knew it was dark. I assume he's an adult, he's crossed streets before. What do we do with all of those other subjective factors that Mr. Vasilenko chose that caused him to be hit in the street that is not under the control of the church, nor did the church do anything to make the street more dangerous?
Well, clearly, comparative fault is something that the defense can argue at trial.
Well, I'm talking about it. I'm not talking about direct causation. I'm talking about the general abstract concept before we even get there of duty. Okay. And it appears, based on Mr. Borstein's arguments thus far, and the cases Mr. Laurier has cited, that we would be creating precedent here by finding duty as a matter of law under these circumstances.
Well, the court would not be creating precedent. In my view, the court would be applying its prior precedents to an extremely analogous factual situation.
What's your best case, counsel?
Our best case would be, Bonanno. The criticism of Bonanno has been that it's a public entity case, but if you look at the public entity theories in Bonanno, they are essentially identical to private liability theories. Under the Government Code Section 835, you have two ways that liability can arise on the part of a public entity, and one is if the public entity creates the dangerous condition, which means creates it in the first place, or increases a risk from a pre-existing condition, and that is completely consistent with private liability. The second one would be if the public entity is aware of a dangerous condition on its property and has a sufficient time to remedy the condition, but doesn't do so. And that's also exactly the same theory of liability.
What I've heard, what I've heard your friends on the other side say about Bonanno is something different, which is that Bonanno is more akin to cases involving, say, mobile food trucks or other kinds of highly mobile establishments where, there were a lot of choices on the part of the defendant in Bonanno as to where to site the bus shelter. Whereas here, if we're looking at things at a relatively high level of generality, there's no indication that a church with a fixed location or any similar establishment will have comparable range of choices about where to situate its parking lots.
Well, the church did have a range of choices, and any business has a range of choices. The church went out of its way to solicit the swim center to be able to use the swim center's parking lot. So the church made a decision to establish a parking lot at that location. They did so many years before this incident happened. During that time, prior to the incident, they were very aware of the extreme danger to its invitees of crossing back and forth from the church and that parking lot. Despite its knowledge of that extreme danger, it chose to continue to use that parking lot when it had no need to use that parking lot. The church's own map shows several different parking lots. It shows the main church parking lot, it shows the pool overflow parking lot, and then it shows, as one of the church's lots, this business plaza lot just down the street on the same side of Marconi, which the church has admitted had unlimited parking on the night of this incident. And yet, despite all those facts, they directed Mr. Vasilenko that you need to park at the
But I suppose if they had done that and Mr. Vasilenko were hit by a car on Root Avenue, you'd be here with the same claim.
We would not be here, Your Honor, because Root Avenue is a much safer street to cross than Marconi, and that is established by the
Unless you get hit while you're crossing it.
Excuse me?
Unless you get hit while you're crossing it.
Well,
so are you saying
it's
that
either safer or less safe, and that doesn't mean you're not going to get hit.
right? So what happens here is Mr. Vasilenko parks across the street. It's dark. It's raining. He chooses to jaywalk. He gets hit by somebody else. What exactly was the church supposed to do? To put a note in the bulletin saying, by the way, if you park across the street, don't jaywalk because you might get hit?
Number one, Your Honor, I would disagree that he was jaywalking. I think we've very clearly briefed this issue. The Sacramento County Code, this was not the city of Sacramento, the county of Sacramento, allows crossing at any point. It does not have to be at a street corner, as long as it's at a right angle.
Did he cross in the middle of the block?
He crossed in the middle of the block, which is a legal crossing because he went at a right angle.
But he crossed in the middle of the block?
Yes.
And he was hit by a motorist?
That is not jaywalking, Your Honor.
Thank you. He was hit by a motorist?
Correct.
So the first person who could have avoided this accident was Mr. Vasilenko?
No.
Who's the first person, the first entity?
Well, let's look at the situation. The defendant controlled the defendant's movements while he was off the defendant's premises. They told him where he must park at the pool lot.
I don't know that that's necessarily an accurate statement. You're saying that the church controlled where Mr. Vasilenko parked? Or was it merely directory, or you can park there, but controlled? Were they going to bar the church door if he parked over in the pastor's parking space?
They didn't literally, physically force him to go into that parking lot, but he pulled into their main parking lot.
That's
the
different.
Attendant directed him, you need to park at this lot. There's no reason for him to reject that proposition. They also told him in this map, you must not park on the streets. So they have control of where he's going to park. This inhibited him from exercising his own discretion about where would be a safe place to park. It doesn't mean he's completely not responsible for any actions he's taken.
Counsel, you started your oral argument by telling us that you are not asking us to formulate a new rule. What is your response to your friend on the other side that says that it would be an outlier and only the New Jersey case supports you? And he outlined a number of other cases that are contrary. What is your response?
We briefed this issue very thoroughly in terms that there are dozens of cases that were cited by both sides. We, I think, very clearly distinguished all the cases that they are claiming are contrary to us, and we presented several cases that are on very similar facts to our case that did find a duty. And I know the court's not taking a straw poll. It's not how it's going to be done. But if you look at Donovan versus Jones out of Louisiana, the facts are virtually identical to those in this case. Lutheran Hospital versus Blazer out of Indiana is extremely similar to this case. Stevens versus Basha out of Arizona is extremely similar to this case. So to say that Warrington is the only case that supports a duty besides the 3rd District in Vassilenko is not correct.
Let me ask you, I mean, from some of this duty analysis is an evaluation of a variety of competing social policies, right?
Yes.
So it's balancing of factors. If there's a duty in this case, one can easily imagine that a church, and I don't know what kind of resources this particular church has, but just take the general case, is just not going to have the resources or expertise to conduct all the traffic studies, all the consultants that are needed to meet the legal standards that you want to impose here. They're going to have to evaluate, this lot, that lot, another lot somewhere else. And by the way, they'll have to evaluate the scenario where no parking is provided at all. So courts are then going to be in the process of deciding which is the appropriate baseline, right, for deciding whether option A is or is not safer than, is it option B or option C? And one could, I suppose there is no rule that says that if the church wanted to provide no parking whatsoever, that would violate some sort of duty, even though it could be less safe for them to provide no parking at all. Because then the parishioners are going all over into the neighborhood around Marconi Avenue, parking in the side streets. They're going to have to walk all over the area, right, and could get hit by a car. And that's because of what? The negligence now of the church for not having provided parking? And if they undertook that study, and that's what the study said, which was that doing nothing is actually the least safe option, then they have to provide parking? Where does this analysis take us?
I think it all boils down to the fact that if the church undertakes to establish a parking lot, it simply has to exercise ordinary care in making that decision of where it's going.
Studying that issue, if the church discovers through a study that it is less safe to not provide parking, do they then have an obligation to provide parking under your test?
No, there's no obligation of the church. They're not required to provide parking, and we have never stated.
If they are required to choose option B, the plaza lot, over option A, the across the street lot, but they are not required to choose option C or option A over option C, which is doing nothing at all, when the study says that option C is less safe, I don't understand that logic. That doesn't follow even basic transitive property. Why would they be required to choose option B instead of A on the ground that B is safer, but not option A over option C, which is doing nothing, when A is safer than C?
Well, these are hypothetical situations, but we have actual facts in this case.
Does it not reveal to us that this is an area that cannot be governed by this kind of standard? Because the nature of the inquiry is so multifaceted and so not susceptible to a clear policy solution through tort, right, that the burden of avoiding accidents here is not intelligently foisted upon the church, because the church isn't in a position to make a good decision relative to the other people, namely the pedestrian and the drivers who should follow the law and avoid, hitting people.
Well, I would disagree about that, because I think the church is in a far better position. A business which is established in a particular place for many years and is, as in this case, fully aware of the danger that it has created by asking people or directing people to park in only one place, is in a far better position to weigh the relative danger.
Counsel, let me try
than
to
a
just
new invitee.
Ask a version, perhaps, of Justice Liu's question in a slightly different way. In tort law, because we are concerned with social policy and costs and benefits, we have to be especially concerned about consequences. And so, if we accept your theory, why should we not be concerned that this may have a perverse effect and lead some churches to simply say nothing about parking in a manner that might be more dangerous to their attendees?
I think if a church says nothing about parking, they allow those invitees to exercise their discretion in full to determine where they're going to park. I would much rather, and it is much more socially beneficial for a church not to direct parking than to direct parking to a place that they know is going to require
I understand your
dangerous
answer
street
better. So
parking.
you're saying, yes, that may happen, but I don't think that that is likely to be dangerous, or more dangerous at least, because then everybody's on their own and they'll exercise their own duty and they'll look after their own interests.
That is true.
Thank you.
So under your analysis, if they just posted a fellow in their own lot that said, sorry, lot's full, and that was it, there would be no liability, even if Mr. Vassilenko parked across the street and chose to cross in the middle of the block in the rain and the dark.
That is true, because at that point, they haven't directed him to do a particularly dangerous thing. They haven't influenced his actions, where if they leave him to park where he wants, he can pick out a safe place to park.
Mr. Vassilenko have an obligation to conduct his own affairs in a prudent way? They didn't say you can't come to church unless you park in the swimming lot, did they?
No, but I don't think that that is a determinative factor in the analysis. He was attempting to attend their function. He shows up. He's on their premises, at the main premises. They give him instructions. He follows the instructions.
If the guard said, lots full, can't park here, there are a number of other lots around, and Mr. Vassilenko picked this one and then walked across the street in the middle of the block in the dark, in the rain, the church wouldn't be liable in your analysis?
That's true.
What does the record show about precisely what Mr. Vassilenko was told?
They told him, you need to park at the pool lot. You need to follow directions. Here is the map. The map has an arrow from where Mr. Vassilenko is.
Are you referring to Exhibit 4?
I forget the name of the number, but it's the map that's reproduced in the briefs.
It's a map with arrows?
Yes.
And it has church parking?
Yes.
Pool parking?
Yes.
And Walnut and Marconi Business Plaza parking?
Correct.
And are you saying that the church is directing its parishioners to use the pool parking only if there's an overflow?
That's exactly what happened in this case, yes.
Is that what they directed him to? Because the map shows parking both in the pool parking and the Marconi Business Plaza.
Right, but they told him you need to park at the pool lot. They used that specific words, pool lot. And they also told that to Mr. Skakoff, who arrived at the lot around the same time as Mr. Vassilenko. So it's not just one person. Mr. Skakoff was almost also injured in this same situation. He and his girlfriend arrived at the main lot at about the same time as Mr. Vassilenko. They were also told specifically to park at the pool lot. They arrived in the pool lot with Mr. Vassilenko at about the same time. All three were crossing back on Marconi at about the same time. They all see this car coming at them at 55 miles an hour. Two of them were able to evade the car. Mr. Vassilenko was not.
Those on the map, they said, be careful crossing the street. Would that have made a difference?
Possibly. They would have at least, there would have been a warning there. Although I think they would have had to have said, be careful crossing mid-block because it is particularly dangerous. Crossing any street is a risky activity. You can get hit on any street. Some are more dangerous than others, and the church knew that Marconi was one of those.
So the average adult Californian crossing in the dark, seeing a car coming at them at 55 miles an hour, needs a printed warning on a map to put them on notice that perhaps this isn't a good idea?
He did not see the car coming at him at 55 miles an hour, and he didn't walk in front of the car when he saw the car coming. The church knew that the speed of the cars...
I was only following up on what I understood you to say. Did you say that the car was coming at 55 miles an hour?
That's what the record shows, yes.
Very well.
But what I'm saying is he did not see this car approaching until 20 feet before that car hit him. So he had no time to react to this car. It's not as if he saw the car and carelessly walked in front of a speeding automobile. All three of those pedestrians were very diligent. Mr. Skakoff testified to the fact that they were very diligent in looking for oncoming cars. They had to wait a while for the traffic to come from one direction to stop. They got as far as the center lane. Now they're in the center lane of a 5-lane thoroughfare. There are cars going by them in both directions in 2 lanes, and they are completely exposed in the center lane. and this was common. In this case, they had to wait in the center lane for a minute. In other cases, pedestrians had to wait in that center lane for up to 2 minutes. This is not a typical street crossing. And after they had sat in this center lane, completely exposed for a full minute, they then, believing it was safe after diligently looking both directions, tried to make that last leg of the crossing. And all of a sudden, this car comes flying out of nowhere and hit Mr. Vasilenko. So I don't think...
How far away was the nearest crosswalk?
Excuse me?
How far away was the nearest crosswalk?
The nearest marked crosswalk, I don't believe the record has any indication of where the nearest marked crosswalk was. There's just simply nowhere nearby. There is under the applicable code, I believe it's the vehicle code, there is an implied crosswalk at every street corner, whether or not it is painted on the street. They knew for years before this incident happened that when people parked at the pool parking lot, they were very likely to then cross directly from that pool parking lot to the church, which was directly on this side of Marconi, instead of walking down to the corner of Route and crossing.
Well, by the same token, I assume that members of the church had traveled Marconi Avenue at different times of day and night in different weather for different holidays. And so it wasn't a surprise that it's a 5-lane thoroughfare with cars moving at a pretty high rate of speed.
Well, it was a surprise to Mr. Vasilenko, who had never been to this property before.
And then he chose to cross it at midnight, in the dark, and a rainy evening.
Well, he was going to cross Marconi either mid-block or at the corner either way, and they're the ones who put him in that position of having to cross Marconi when he did not have to do that.
They, meaning the church, put
Correct.
Mr. Vasilenko in that busy thoroughfare? He had no part of this himself?
He had a part. I believe if you look at the Bonanno case, for example, there's comparative fault assigned to pedestrians, to motorists, to the transit authority. It's not that 100% liability is going to be placed on the church. There's going to be comparative fault assigned to the driver, probably a very substantial amount to this driver who is driving above the speed limit in the dark, in the rain, while trying to deliver a pizza quickly. So there's going to be probably a majority of fault assigned to the driver. There may be some fault assigned to the church and some fault assigned to Mr. Vasilenko. I don't think there's any injustice in that, no unfairness to anyone, and I think it allocates the fault in a way that a jury
if we
allocates.
find the first matter of law question of duty.
Correct. I wanted to address the argument that was raised about premises liability. Defendant is relying on the premises liability defense basically on the theory that's been stated in other cases as, to find a duty here would take the premises out of premises liability. But in Kessner, this court rejected that truism. It recognized that premises liability is just another species of negligence. And you're going to apply the same negligence standards in whether it's called a negligence case or a premises liability case. Roland v. Christian itself was a premises liability case. So there's attempting to recharacterize it as a premises liability issue versus a negligence issue is not going to avail the defendants at all. And in fact, the plaintiffs have never framed this as a premises liability issue. Both the third and the fourth causes of action are framed as general negligence causes of action. So there's nothing to be gained for the defense there. This case is similar to Anaki. It's similar to Barnes. It's similar to Swanberg versus Omecton. Various other cases when it's viewed as a situation where the plaintiff was not on the defendant's land at the moment of the plaintiff's injury, but the defendant, through conduct or some condition on the defendant's land, created or increased the risk to someone not on their premises. And that is not a novel concept. This case is also similar to Bonanno and also similar to the explanation given in Alcarez about a Court of Appeal decision, Hamilton versus Gage Bowl. The Court of Appeal in Hamilton versus Gage Bowl said that a defendant bowling alley owed no duty to the bowling alley's invitee who was in the bowling alley's parking lot at the time that a sign detached from a building adjacent to the parking lot and landed on the plaintiff there, because that defendant had no notice that that sign was at any risk of detaching and falling, and had no power to go onto the other property and inspect the sign to check whether it was faulty or not. Alcarez explained, however, in that case, if the bowling alley did have notice that that sign was at risk of detaching and falling, then the bowling alley would have been liable for that. So that is precisely the same situation as existed in the Bonanno case. Bonanno considered the plaintiff there to be a user of defendant's land, even though that plaintiff was not on defendant's land at that time. The court found that she was no less a user of that land because she was attempting to access that land at the time of her injury. And they used the analogy of, well, what if the defendant required the defendant to jump over a ditch in order to reach its land? If the plaintiff had fallen and injured herself in the ditch, then the defendant would be just as liable as if the plaintiff had fallen while on defendant's property. So the principle is that the defendant had actual notice that a danger on adjacent land exposed persons using or attempting to use defendant's land to a risk of harm. So I don't see that recognizing the duty in this case is in any way an extension of pre-existing law. It's merely an application of pre-existing law to a different set of facts. Another point I'd like to make is the distinctions between this case and cases like Sieber and Steinmetz and Navarez are that in all those other cases, the only connection between the defendant and the injury that was suffered to the plaintiff was that this hazard happened to be near the defendant's land. The defendant did nothing to increase the risk. The defendant did nothing to cause that person to encounter the hazard. This is in contrast to cases where defendant's negligent management of its property did increase a pre-existing risk of harm from street traffic. And that would be Bonanno, Anaki, Barnes. And the idea that well, there should be no duty because you're on your own if you're a pedestrian doesn't fly when you look at Bonanno. Bonanno didn't say, well, tough luck, plaintiff, you were required to cross a dangerous street, but you should have been a little bit more careful before crossing. If you look at Anaki, the person in Anaki who was the plaintiff was the decedent in that case was a passerby, wasn't even an invitee of the restaurant. The restaurant set up its parking lot in such a way that its patrons were likely to leave that parking lot in a way that created a danger to people who were on the Pacific Coast Highway. They didn't advise the person that they couldn't turn left. So the person attempts to turn left, said you can only turn right. And as a result of that, this motorcyclist who's passing by collides. And the court found not only that there was a duty owed to the invitee to give the invitee proper warnings when it had knowledge of this danger, but also owed a duty to this mere passerby. And there were thousands of passersby every day on the Pacific Coast Highway. And if that restaurant created a risk in the way it managed its parking lot, then it owed a duty to all those thousands of invitees. That is a far greater scope of duty than restricting the duty as we have offered to invitees only of the defendant, where the defendant establishes a lot in a place where it knows it's going to be dangerous to have ingress and egress and requires people to use it. There's no burden. I don't think there's any consequence to society other than a beneficial consequence to society. I'll conclude, and I see I'm almost out of time, but if you take a step back and say, well, what is this case really about? It's an interesting law review examination, but there was a series of very, very bad decisions that were made by the defendant in this case. I would submit that those decisions were indefensible based on what the church knew about the danger it was putting people in, and that there was no social utility to what the church did, and that this is not the sort of activity for which the church is entitled to a categorical immunity. I'll conclude unless there are any further questions.
Thank you, Mr. Tarana.
Thank you.
I think the questions by the court makes it clear that the church had no control over Mr. Vasilenko when he chose to cross the street in the manner that he did. He's not an automaton. He's given a map with various areas that he can park his car. This is a situation where he can no longer park at the location of the church's general parking lot. And I believe Justice Chin, your question about the pastor's lot, I don't believe that lot was available. The issue is, where is he going to park now that the parking lot's no longer available?
That lot would actually make it more dangerous because he would have to cross two streets.
That's right, and I think that the issue we have here is one of, we look at the facts in a more generalized sense under Cabral, because the issue is there a duty of care in making somebody cross a public street? And he's not being made to cross a public street. It's just a public street is there. Crossing a busy public street is not an unreasonable risk of harm. It just cannot be conditioned that way. In all the cases in Anoki and in Barnes, the courts find that it is a condition of the premises. And in Anoki, the court makes it clear that the driveway leading out of the parking lot is confusing to drivers, and they might turn left and cause a motorcycle accident or some other condition. In Barnes versus Black, it's very clear you have a steep driveway that ejects a child out into a busy street. None of those conditions occur in the church's parking lot. Bonanno, the court found the location of the bus stop a dangerous condition of government property under the government code, of public property under the government code. There's no finding. There's nothing wrong with the adjacent parking lot that the church uses that ejects people out into the street or caused this accident.
I think the claim on the other side isn't about the nature of the property and any misdirection given at the property. It's about the siting decision, where to locate the lot. And I pressed counsel on the notion that I think we can all agree the church has no obligation to actually have a lot, but we could say that if it is going to have a lot, it should choose the best one.
Well,
doesn't that seem like a decent rule of thumb?
Well, no, Justice Liu, I don't think so, because that's not in our modern society in the way premises or business owners have available to them off-site parking. They may have more than one lot available. And to put a burden on premises holders to decide which lot is relatively safer than another, say in downtown San Francisco or anywhere, which lot is more safe than another, We have to cross Market Street. We have to cross other streets. This is not an unreasonable risk of harm.
Mr. Laurier, your time's expired.
Thank you.
All counsel, thank you. The matter is submitted. Calling the matter of the People versus Christopher Henriquez, and sitting on assignment, we welcome the Honorable Herbert I. Levy, Associate Justice, Court of Appeal, 5th Appellate District, assigned. And when you're ready, counsel, you may begin.
Good morning. My name is Oscar Barbaro. I'm here to, with the court's permission, argue the denial of a fair cross-section in the jury veneer. Mr. Kaufman, my co-counsel, will address Argument 8 regarding vengeance and any other issues and answer the court's questions in all other areas. I do wish to reserve 5 minutes of time for my rebuttal. If there has been a chronic and significant underrepresentation of a protected class of potential jurors for decades, the jury commissioner must take remedial measures in an attempt to correct the disparity unless there are compelling reasons for maintaining the status quo. But here, the only actions taken by the Contra Costa County Jury Commissioner exacerbated the problem. In the trial court, the government and the trial court did not dispute that for over a 20-year period, leading up to and including the summon veneer in this case, Contra Costa County engaged in a system of jury selection that consistently underrepresented a significant portion of the African-American residents in the jury system. So at the time of petitioner's trial, it became clear that the underrepresentation of African-Americans in the jury veneers in Contra Costa County had become inherent in the process of jury summoning. This is acknowledged in the trial court record, and it is extensively documented and acknowledged in a multitude of Contra Costa trial and appellate court cases, and in the decisions that preceded this case. The jury commissioner has been a party to all of those case decisions detailing this phenomenon, and this court acknowledged the disparity in 1989 in People v. Bell, and the Bell record was established in 1979. It is the government through the jury commissioner that is solely responsible for the operation of the jury system, and thus it is their obligation, required under the Constitution and by statute, to develop a system in a manner that produces a fair cross-section of the community served by the court. The language of the prosecutor who opposed and litigated the motion to quash the petitioner's case and litigated the case in People v. Curry for months before this case stated, "No one is defending the historic underrepresentation. Even under the best scenario today, there is an underrepresentation of African Americans under the best view of the jury commissioners and the people's evidence."
So our cases are, as well as the United States Supreme Court's cases in this area, are clear that to make out a violation requires more than just underrepresentation. It also requires traceability of that underrepresentation to an improper feature of the jury selection process. What, in your view, are the improper features of the process at issue here?
They're fivefold. The jury commissioner made the decision to hold only misdemeanor trials in the courthouse located in the city of Richmond. In the face of the evidentiary record we presented in this case, which was not presented in the Curry case, but was presented in Mr. Enriquez's case, we established that the African American population of the area of that county was in fact appearing for jury service consistent with their numbers in the population. The African American population in the West County area, the area served by the courthouse in the city of Richmond, was approximately 23%. The African American population that showed up for jury service in that location was 26%. That's the evidentiary record. The decision by the jury commissioner was, we are not going to hold felony trials in that location. We're going to hold them 20 miles away in the city of Martinez, despite the evidence that we presented.
So my understanding on that point is that the trial court looked at that argument and said that actually the statistics don't bear out that the location of the courthouse has a meaningful effect on the rate of African American jurors showing up for jury selection, and that it's really other factors, principally failure to appear, that seem to be causing the disparity.
I think that the trial court's comments about the failure to appear ignored the actual evidence that we presented on who is appearing and who isn't appearing. And the trial court, in reviewing those comments, seemed to equate the failure to appear numbers in the Bay Judicial District, where the Richmond Court is, and the failure to appear numbers with the Martinez Courthouse as being the same, and therefore it basically is a wash. It's not a reason to find a inherent feature is problematic with the jury selection process, or the jury summoning process. But that ignores what the feature that I just talked about, is that the jury commissioner and the representative for the jury commissioner, I was going over the actual trial court record yesterday, and the county council made a statement that the jury commissioner doesn't know who is not showing up. They don't do any kind of follow-up to determine whether or not the failure to appear rate in the Martinez Courthouse is in fact an African-American population, or the failure to appear rate is an African-American population in the Richmond Courthouse. They don't do any of that determination. And so the point I'm making is that the Richmond Courthouse evidence is that there is not a failure to appear of African Americans in that location in proportion to their numbers in the population. And the decision by the jury commissioner to only conduct misdemeanor trials in that location ignores that evidence and further entrenches the system of underrepresentation in the courthouse in Martinez.
There are reasons to believe that the failure to appear rates might be different between African American residents of the Bay District and other residents?
Well, we put on extensive testimony about the inability to travel, and that is one of the issues, one of the other issues, the inability to have public transportation from the location of African Americans in the largest concentration of where they live in the county, in the Bay Judicial District, that is serviced by the Richmond Courthouse. It's 20 miles to the city of Martinez. It's also 20 miles from the other pocket of the largest segment of the African American population. And to only hold felony trials in that location without public transportation from those two locations further entrenches the inability of the African American population to arrive at the courthouse where the felony trials are being conducted. And again, it has to be juxtaposed with the evidence that we presented in regard to who is showing up in the courthouse closest to the population centers where the African American population resides. And so that second decision by the jury commissioner to hold only felony trials in the city of Martinez 20 miles away from those locations further exacerbated the situation. And the hardship excuse policy that's on the printed jury form that's in the record here says that if it takes you more than an hour and a half to get to the court from your location, you are excused from jury service. And we put on testimony in the Curry record, which was part of the Enriquez record, that it takes almost 2 hours from a number of locations in the Bay Judicial District to get to the courthouse in Martinez. And so there's a hardship built into the way that this is being conducted, and yet the jury commissioner continues to operate in that fashion. The other decision that the jury commissioner makes is to hold misdemeanor trials in the courthouse in Walnut Creek, which is in the south section of the county, for misdemeanor cases that come from the largest and most populous section of the city in the county, which is Concord. They move those cases, those misdemeanor cases, out of the city of Martinez and not held in the courthouse in Martinez in order to make room for, again, only felony trials to be held in that central location 20 miles away from the largest segments of those populations. So that's their third decision. And the fourth one is the arbitrary decision to divide the county into 4 different judicial districts and to summon an approximation of the percent of the population in each. But when actually summoning, they're summoning less jurors from the districts with the higher concentration of African Americans and more from the districts with the lower concentration of African American residents. That's evidenced by their summon yield report. They get a report that says, this is how we're summoning. We made the decision in order to do it this way. We're going to divide the county up into 4 different districts and summon according to the numbers that we believe are in each district. And then based on the report we get about that summoning process, it shows us that we have an underrepresentation of residents from the areas where the highest concentration of African Americans live. And knowing that, what do? They summon again the next year in the exact same fashion. They're entrenching this system by decisions that they're making in order to perpetuate it rather than correct it. Finally,
so is one of the remedies that could have been employed to summon a larger proportion of African American potential jurors to counteract the failure to appear rate?
I believe so. I believe that the county could engage in whatever remedial measures it saw fit in order to better reflect the African American population of the county.
If we begin with the premise that being summoned to jury duty, compelled by the government to show up someplace and be away from your family and your work and all of that is a burden, then, and I think we can all say that, because probably most of us have been summoned to jury duty, wouldn't a counter-argument then be made that the African American population is being imposed upon unfairly because they are being overly summoned to be away from work, et cetera, et cetera?
I don't know who would raise that objection in light of the fact that, as this court obviously knows, the criminal justice system prosecutes minority populations in gross disparity to the way it prosecutes Caucasian citizens. And to say that the African American community would be taken aback or pose an objection to being more involved.
I'm not suggesting that people might or might not be in favor of such an alternative. I'm simply observing that if you say we're going to subpoena people based on their race, recognizing that it's a burden, that is something that at least should be considered in the mix, or do you disagree?
I don't know that it would be considered a burden. I think what it would be doing is saying, look, the way we're summoning now is not getting us the equal numbers of the population that we should be getting in the summoning process. We're summoning 4 different districts. We're getting less than the district population that has the largest segments of the African American population in that pool by doing it this way. And so the suggestion of should we over-summon from the areas in which those populations and those people live, yes, we should, because that way we would get an equal number, at least, or a greater number of the populations that come from that county. But doing it the way that...
I get it. So at the outset, you said that there were 5 actions by the government that
Yes.
result in this disparity, and
Yes.
we've heard about 2 of them.
No, I've
And I want to
actually-
make sure you get a chance to fill out the other 3.
Sure. There were. I thought I had been through 4. The first was to hold all the felony trials just in Martinez. Sorry, the first was to
Misdemeanor
hold only
trials
the
only in
misdemeanor
Richmond.
trials in Richmond. The second was to hold only the felony trials in Martinez. The third was to move out the misdemeanor trials that occur in the largest city in the county to the Walnut Creek District in order to make sure that the felony trials can be held only in Martinez. The fourth was to divide into those 4 judicial districts and summon in that fashion in light of the numbers that are produced by the summons yield report. And the fifth is the continued decision to only summon jurors using voter registration and the Department of Motor Vehicles lists. And I know that those lists, and there's been a great number of cases that deal with those lists being deemed race neutral. But we put on expert testimony that those lists do not give you a race neutral group of jurors when they're being summoned. And the Code of Civil Procedure allows for additional lists to be used. And the jury commissioner, in the face of that expert testimony and that underrepresentation, and in the face of the report from the California Judicial Council, which examined racial and genetic bias and recommended, that the courts be cognizant that minority residents are more likely to vote in lower numbers and disproportionately live in poverty and have less economic means than other citizens of the county, that despite that information and the fact that the court took judicial notice of that report and the fact that our expert testified that using those 2 lists underrepresents African-American citizens in the jury pool, the jury commissioner has chosen again to only use those 2 lists. So there are 5 strategic operational decisions that are being made by the jury commissioner that are choices, basically, in order to entrench this system of underrepresentation that's been documented by this court and several other courts before it, and to continue with this system despite the clear denial of a fair cross-section. So to say that this is just as the people do, to say that this is just a complaint based on the fact that there is a statistical underrepresentation is not an accurate representation of the record. The record is that the jury commissioner has been made aware of this underrepresentation and has done nothing to correct it. The Duran case, upon which all of this litigation stems from, said that statistical evidence that simply tends to show a causal relationship between the underrepresentation complained of in order to establish a prima facie case of systematic representation can be enough. And in Duran, there was only a year of underrepresentation that was presented. Here we have an admission and Court of Appeal cases of 20 years. And so really, I stand here before this court and ask, at what point does this county's system of jury selection, which is documented to underrepresent the African-American population, at what point does it become a constitutional violation, a systematic violation of the right to a fair cross-section? I think the point is now. I think the point is this case. I think the point has been established in this case by the record that we presented, by the evidence that we presented, and by the failure of the jury commissioner to do anything at all to correct it. This court has stated that inclusivity in jury service promotes citizen participation in government, legitimizes judgments of courts, and prevents further stigmatization of racial minority groups in our society. To say that 20-plus years of underrepresentation doesn't even rise to the level of a prima facie case of systematic exclusion, especially in light of the jury commissioner's intentional actions that I just outlined, that were taken to ensure the continued operation of the current system in the same manner, and no action or effort to remedy the situation, seems simply absurd. By finding petitioner was denied a fair cross-section here, we're simply asking this court to right an identified wrong that no one reasonably disputes exists.
Mr. Barbara, you'll have 2 minutes for rebuttal.
Thank you.
Good morning. May it please the Court. Scott Kaufman from the California Appellate Project. I would like to briefly address Argument 8, subsection D, related to the vengeance question that was raised in the AOB. In this case, the district attorney explicitly argued that the victim's family is entitled to vengeance, plain and simple. And this was in the context of an extensive presentation of victim impact evidence, which included other people who weren't even members of the families of the victims. It was an extraordinarily emotionally charged case. And it was a very, very difficult case. And to add this layer of vengeance to it, I think, crossed the Eighth Amendment line. And this is an opportunity for this court to finally rein in a little bit of what is going on in the trial courts in relation to the presentation of victim impact evidence.
Does our decision in People versus Sanchez last year help us resolve the claim of prosecutorial misconduct in this case?
I don't think Sanchez was as close a situation as in this case. I think this case is a clear presentation of an argument by the district attorney relying on the issue of vengeance for particular victims of the case. This is not a situation like in Zambrano, for example, where there was a discussion about the right of the community to extract vengeance, the right of the community as an abstraction, as in a general way. In this case, he was specifically referring to the victims themselves and suggesting that they deserved vengeance that could only be imposed through the community action. The problem is, in the context of... Go ahead, I'm sorry.
Agree with you, is it harmless error?
I'm sorry?
If we agree with you, is it harmless error?
Well, I say no, it's not harmless error. I would like to start off by saying I think it's structural in this case because I think it's difficult to truly assess it. But I would say this. This case has a multiple number of issues related to instructions that were given and statements that were made to this jury about weighing, whether there's the weighing process and what the weighing process is involved. There was extensive discussion regarding whether there would be, whether there was equality between mitigation and aggravation, whether if you had no evidence of mitigation, would that be sufficient for a jury to find life, even in the absence of mitigation? And tied to that as well was an argument related to the absence of, or the prevention of the defense attorney from arguing for mercy, which is also, there was an assumption that mercy was somehow covered under the ideas of compassion and pity and sympathy. And I suggest to you that's not the case. When the district attorney is allowed to argue vengeance on the one hand and the defendant is not allowed to argue for mercy on the other, that's an unfairness. And the prejudice flows from that unfairness because it's not a fair distribution.
Counsel, is it your position that the use of the word vengeance, even if it's isolated by the prosecutor, is not only error, but it's structural error, even if it's just one mention?
I'm saying that this has to be taken in context. It has to be taken in the whole. You can't look at it in isolation and just say, well, it's a small statement. He only made that statement once. And I should point out, by the way, there was an objection made, which also distinguishes this from Zambrano. There was no admonition given to the jury. There was no instruction given to the jury not to consider vengeance. And
was there a request for one?
I'm sorry? Was
there a request for one?
There was not.
So there was an objection made. The objection was sustained. Prosecution was admonished to honor
She was told to comport yourself accordingly. That was what she was told. And then she immediately said thereafter, the death penalty is here so that victims, in a sense, have a voice. What is justice in this case? So again, she's pointing back to the victims and their desires and rights for vengeance. She's implying that she has some sort of
well, the dead
knowledge.
Victims are entitled to a certain degree of justice as well, are they not?
I'm sorry.
The deceased victims are entitled to a measure of justice as well, are they not?
Certainly, the deceased is entitled for the entire community is entitled to justice.
So
but the question is whether they're entitled to
reference to victims is somewhat more inclusive than the surviving family members. Isn't that right?
It's the focus on the victims individually, which is what happened in this case, is what distinguishes this from Zambrano, I think. And to that extent, I think that's where it crosses the line. And what I'm suggesting to you is that this is an opportunity for the court to put some limitations on what kind of arguments the district attorneys are allowed to take. What happened here is that this district attorney is obviously a very good lawyer. She has been following the case law. She has seen the development of the case law. And she realizes that she might be able to make this argument and stretch it a little bit further. And that's exactly what she did. And she got called on it. There was no admonition. But the fact is that in the context of the entire argument, it was inflammatory. And it really did step over the line of the Eighth Amendment. Now, as to whether or not it's harmless error, I submit to you it's not harmless. But in any event, I still think whether you find this is prejudicial to the case or not, I think it's important for this court to set some real limits on what district attorneys are allowed to say in the context of victim impact.
Can I ask a clarification? I think I understand your point, and that is that you admit that the prosecutor did not request vengeance on behalf of the victim's family, did not expressly say that, and in fact sort of disclaimed it and said that the victims are not entitled to personal vengeance. But then goes on to say, and that's all proper, but then goes on to say, in return, they, the victim's family, are entitled to vengeance, plain and simple, from the state, because they're not allowed to get it themselves. Is that statement improper? Just expressly not out of context, but in isolation?
I think it's improper. I think it's a violation of the Eighth Amendment as a...
Is it a violation of Zambrano and or Sanchez, as we have said in the past when we've talked about request for community vengeance is not improper?
I think it is in this case, because I think it's in the context of the other victims. There's specific victims.
So expressly that phrase is not a violation, but you're saying in terms of the entire argument that the DA made about the victims here, yes. It is?
Yes, that's exactly right. That's right. Anyway, if you have any other questions, I will submit it.
Thank you, Mr. Kaufman.
Any other questions at all? Okay, thank you.
May it please the court, Ronnie Pomerantz on behalf of the state. I'll first start with the fair cross-section arguments that have been made here today. I want to address first appellant's assumption that there is significant and chronic underrepresentation of African Americans on Contra Costa County jury veneers, and that this was somehow assumed to be true below, or that this was somehow conceded below. I don't think that's the case. I would start first with the fact that the prosecutor heavily litigated this issue below, and specifically said below that he did not agree with the numbers that were found in Curry, and that he wished to build on the record in Curry. But I would also point this court to the fact that since 1982, I believe, which is our first published opinion on Contra Costa County jury veneers in People v. Buford, the California Court of Appeal decision, since that case, we have not had a decision that has addressed Contra Costa County jury veneers, which has actually found a constitutionally significant underrepresentation of African Americans on Contra Costa County jury veneers. And to the contrary, there's actually been a downward trend in the underrepresentation that these decisions have shown us. For example, in Buford in 1982, I believe the highest number, the absolute disparity there was up to 7.2%. Subsequently, in 1984 and 1985, there were decisions, Court of Appeal decisions, that talked about the number being in the mid 4% area. Finally, or later in Bell, this court found that a 5% absolute disparity was insufficient and was not a constitutionally significant disparity. And then finally, in Curry in 2001, the California Court of Appeal, in addressing this precise issue, declined to decide the issue, but noted there that there was a 3.8% absolute disparity, and that did not rise to the level of the 5% absolute disparity that was present in Bell. And so I just wanted to first point out that to the extent appellant is making this assumption and holds that all the parties below made this assumption, or that this court should make that assumption, I don't believe that the case law bears that out. And I would just conclude that point by pointing out that here the absolute disparity is 3.5%. So it's by far the lowest underrepresentation that we've seen in any case discussing Contra Costa County. Moving on to some of appellant's other points on the fair cross-section issue, I just want to point out that appellant speculates that there are remedies that Contra Costa County can undertake to address the underrepresentation, but even putting aside the fact that a county's failure to undertake a remedy, even putting aside the fact that that is not legally material to this court's decision under Duren or under the fair cross-section analysis, the trial court below did engage in these proposed remedies and did consider the speculation that certain remedies might work. And the trial court did present statistics, which were actually not disputed below, about how some of the speculative remedies would work, and found there was no basis to find that found there was no basis to find that the defendant's proposed remedies would actually increase the percentage of African Americans on the jury veneers. And that were things that included the transportation issues or the geography issues that the appellant has posed here.
What about the use of voter lists that are derived entirely from motor vehicle records and voting records?
There was speculation below that the county could be doing more to supplement those lists. I believe the trial court actually invited argument on this point and said it wasn't clear to the trial court what additional lists Contra Costa County should be using. And of course, it is conceded, I believe here too, by appellant's counsel that the DMV and voter registration lists are race neutral and are acceptable under California state law. So I do think, again, Your Honor, the trial court here did sort of engage in the speculation and invited counsel to suggest additional lists, but that there was no satisfactory suggestion that was made below. And as this court is aware, I would also point the court to the fact that there have been several cases that this court has decided in which defendants have claimed that counties should supplement the source list. And that, again, the failure to supplement race-neutral source lists can't be in itself a violation of the Sixth Amendment or in itself a prima facie case of systematic exclusion.
Not a piece of evidence that can be considered?
I believe it could be a piece of evidence that could be considered. And here I would point again to the fact that the trial court did engage in this discussion with counsel and invite proposed remedies from counsel just on the question itself of what was wrong with the source list. And below, trial counsel for all the defendants present weren't able to point to a single factor that was wrong with the source list, and they weren't able to point to any other source lists that they believed would be feasible to implement or that would actually result in a greater proportion or percentage of African Americans on Contra Costa County jury veneers. So to sum up, I believe certainly a trial court could consider that along with any other evidence that a defendant wished to present. Moving on to the prosecutorial misconduct issue. Here, I think it's very important to note, and it seems that appellant's counsel and I agree on the fact that the prosecutor's comments should be placed in context. I think where we disagree is about what that context means. I think here the prosecutor began her discussion of vengeance and retribution a couple pages, or perhaps 10 or so pages, I'm sorry, I can't remember exactly how many, before the challenge testimony. And that's when she first introduced the retribution and vengeance argument. And in doing so, this was first introduced in terms of a societal imposition of vengeance or retribution. And the prosecutor specifically linked this concept of retribution and vengeance to the idea that society should say enough is enough, and that's a decision that the jury should make in acting on behalf of the community. So I do think it's important to note that the prosecutor, when she first brought this up, there was no mention of the victim's family at all. Turning to the challenge testimony more specifically, even there the prosecutor placed this idea of vengeance and retribution in the context of societal or communal retribution and vengeance, and talked about it similarly to this court's holding in Zambrano, talked about it as being a proper form of punishment in lieu of the right of the individual's personal ability to exact personal retaliation. And I do think that that was a concept that this court reiterated in Zambrano that was important to remember when discussing societal vengeance in lieu of personal retaliation.
I would buy that if that's what the language actually says, but this is what it actually says. It says the victim's family are entitled to vengeance, plain and simple, from the state because they are not allowed to get it themselves. That would be called vigilantism, and that is not allowed. And the state owes the victim's family something in return, doesn't it? It owes them what they are not entitled to get on their own.
I agree that the prosecutor did reference the victim's family in that discussion, but I think in context of this larger discussion of retribution and vengeance, the prosecutor did posit this discussion as part of the societal sacrifice of personal retaliation. And I would point out that prior to the challenge testimony, the prosecutor said, we are not allowing the Jones family, again referring to the Jones family, but stating, or any family, or any victim's family to take personal vengeance on a defendant. So I think here what the prosecutor did is begin with the Jones family, but explain how the community as a whole could not take this type of personal retaliation.
I think the bothersome part of it, I mean, everything you say contextually may go to whether or not this particular statement was prejudicial or not. But as to the statement itself, what it is saying in its own terms is that the state is giving to the families the vengeance they are owed. I don't see how there's any other way to read this language, and that's just not permissible. I mean, that is buying into the notion that the state owes the families their private vengeance, which they cannot extract themselves, but the state is going to give it to them. That's what it says.
I agree, Your Honor, that I think without the additional language, we would have a much closer case. But
what is the additional language, just to be clear, that you think mitigates what Justice Liu just read?
I believe in the context that the prosecutor first introduced vengeance and retribution, and then in the earlier lines which preceded the challenge testimony, which talk about the Jones family or any victim's family to take personal vengeance on a defendant. I think the prosecutor began by talking about families and impliedly talking about this idea of community in general. And so I do think that while Justice Liu's concerns about the challenge testimony, I do understand those concerns. I think that if we're talking about this specific challenge testimony, it was introduced in this manner that was describing society as a whole.
So it has to be read in context, is your point, and we may or may not agree that there's enough context there to pull back from perhaps the implication that the testimony, or rather the words have on their own, but it sounds like you're conceding that on their own, those words are pretty troubling. But they might be a mistake on the part of the prosecutor were there not other language to put them in context.
Your Honor, I think in determining whether there's misconduct on the cold record, this court would have to ask if it's likely that the jury misunderstood those comments to mean that the prosecutor was arguing for vengeance or retribution, specifically, as Justice Liu said, to enact a private or to execute retribution for a private wrong. And again, I'm not conceding that there would be error here because of the context. And given the context, I don't believe a jury would have understood that language to mean that. And I do think we would have a different case. And again, I would need to know the complete facts in that hypothetical. I think we'd have a somewhat different and closer case.
Very different. I mean, it's a rather simple hypothetical. It's simply there's no more context. I mean, there's no more context that has a bearing on this, right? This is the only mention of vengeance in families. And it sounds like in that situation, it seems to me, your argument suggests that it might be on the other side of the line if we only had that language.
I'm sorry, Your Honor. Yes, I believe based on that hypothetical in a vacuum where vengeance and retribution is brought up in this surprise manner without any other kind of context, I do believe there would be a much stronger case to state that the jury was being asked to impose retribution or vengeance to retaliate against a private wrong. I would point out again that here, or in addition, that here we also had an objection on the record in which defense counsel stated that there is no evidence that the victims wanted or the victims' families wanted this type of punishment, and the trial court sustained the objection. And I would also note that in concluding, the prosecutor here concluded her closing arguments talking about the community as well, stating that the jury speaks collectively for the community and that the jury's verdict should be a statement that the community will not tolerate this. So I think we don't have a case where there is some sort of very emotional harping on the idea that the victim's family wanted the death penalty in this case. And just to respond to another one of the points that defense counsel made on this point, it's not the case that the victim impact evidence in this case was highly emotional or that it was even substantive. There were 4 victim impact witnesses that testified, and I believe their testimony, in closing argument, I believe the prosecutor devoted about a page to that testimony, did not discuss in any arguable way at all whether or not those individuals wanted the death penalty, but instead focused her comments solely on the fact that these individuals testified that they missed their daughter and they missed their granddaughter, and that it was a horrible experience for them to lose them in this way. And so I don't think it's true that there was some kind of emphasis on victim impact testimony in this case. And I think that also relates to the prejudice argument that we've been discussing here, that I think certainly if one is going to take the actual evidence in the record coupled with the objection that was sustained in front of the jury, there's simply no basis upon which to infer that the jury was likely to take the prosecutor's arguments to mean that the victim's families sought the death penalty. And seeing that there are no further questions, I would ask this court to affirm the verdicts. Thank you.
In response to the arguments in regard to the fair cross-section, that no court has found that the disparity in regard to the underrepresentation in Contra Costa County has risen to the level of warranting a reversal. The Buford case did find that. The Bell case did not find that, but the Bell case did not, as the prosecutor just stated, rest on an absolute disparity determination. In fact, the Bell case at length discussed the fact that the Supreme Court had not yet adopted, at the time of the decision, whether an absolute or comparative disparity test was the appropriate test, and it was not reaching the issue of whether or not 5% of an absolute disparity test was in fact violating the Constitution, but rather was deciding the case on the systematic third prong of the Duren test. And so it did not rule on 5% being an absolute disparity being constitutionally insignificant. And in fact, we cited in a letter brief to this court, in an almost identical population, the Supreme Court of Iowa just this year decided the issue of absolute and comparative disparity and spoke to why comparative disparity is much more applicable to a small population. I mean, if you assume that the people's position that absolute disparity should be considered as a determining factor, if you have a population of 10% or under and you don't have any representation from that community in the jury pool, you'd have an absolute disparity of 10%, but you'd actually have a comparative disparity of 100%. And so I mean, how this played out for Mr. Enriquez, there wasn't a single African American on the panel that voted for him to die. And the panels that were summoned underrepresented the population in that county. And a comparative disparity test, which has now been adopted by the Ninth Circuit and been allowed for by the U.S. Supreme Court since Bell, the comparative disparity in this case was approximately 45%, and that was found by both the court in Curry and the court in Enriquez. Both those trial courts said that based on the evidence presented, we have approximately a 45% underrepresentation of the population that should be appearing for jury service. And so the comments of counsel, I don't believe are accurate in regard to how this court should make its analysis. And then finally, on the whether we concede that the use of Department of Motor Vehicles and voter registration lists are race neutral, we put on expert testimony that they were not, that they did not have a race neutral application. Hiroshi Fukurai, who testified from the University of California at Santa Cruz, wrote a book on this, on how those lists are underrepresented. And what I said in some of my initial comments were that the courts have been instructed to take notice of the underrepresentation in these two lists. And what is the reason for having a code of civil procedure that allows for other lists, which we suggested could be used, like utility lists, which are used in the state of New York, in order to get a more inclusive population in the jury pool? Why would we have that in a statute if there isn't a reason to use it? And
Mr. Bobrow, your time's expired.
Thank you.
As all counsel is aware, this matter is not being submitted at this time and will be submitted or considered submitted at the time of appellant's filing of a supplemental reply brief as per the briefing order. I thank you all for your arguments. We stand in recess.